One that for non-prosecution 81.
Huh?
For non-prosecution, I can know 81.
But I mentioned
Give.
I mentioned contempt application.
Give the slip.
The matter is 81.
81.
Yes.
Huh.
Anytime may be taken by law.
You have a written instruction.
Yes, ma'am.
Let it.
I mentioned contempt application. My lord.
Huh?
Contempt application.
Today is not the mentioning date.
It's
Yeah.
for the urgent matter, my lord. Okay. For the petition.
Yes.
Serve the notice upon all respondents. This is my service, my lord. In India, no, they have rang me also. But I will what happened. Petition of your lordship is a partnership firm is a enlisted contractor in military engineering service under Eastern Command. But I have challenged the order of suspension of my business as a contractor that I have challenged at page 48 because I just place the facts of the case, my lord. But it is enlisted. I was enlisted. It's a conditional given. Then this is renewed. Then, my lord, I got certain works in 2023 in Lakshadweep, my lord. You also knows better than me in Lakshadweep Islands, my lord. I executed work. And that is like, I annexed these works and I did it, completion certificate also given. Now, what happened? In Lakshadweep, I got introduced to a person named Nasir. Introduced to Nasir because there's some logistic problem. I took the help from him. I sent the money to the accounts of the Nasir's sister and father, who on this turn given to Ibrahim Ali, a engineer of this garrison engineer at his office, who had paid to the laborers. Subsequently, my lord, CBI initiated a case against that Ibrahim Ali, that officer, and the Nasir and myself, farm. This is a case that illegal gratification, also through bank transaction. This case is pending. I have been called under Section 41. I complied with. It's not going on. On the basis of that factual aspects, they have issued the first show cause notice. This is my given. My lord, people can come to page 44. Sorry, madam. At page 45, they given me show cause notice.
Yes.
And they say this is illegal gratification, but this case is at the stage of investigation. This is not nothing. Even the officer has not been arrested. He was rather promoted. Then when I give the reply, what's happened, I reply. Now they have placed me under suspension. Order is at page 48. At page 48, I just place it. Reply submitted by your letter referred paragraph A1B has been examined in the headquarters. Your reply is not found convincing at all. Your firm has prima facie been found guilty of adopting unethical practices. In this connection, please refer to para 9 of your enlistment letter, issued under. In view of the above, your firm is hereby suspended temporarily for business dealing with immediate effect from first year for first 1 year from the date of this letter. Next part is please note that the suspension shall remain in force until same is revoked in writing by the registering authority. So the order was passed on the basis of para 9 of this enlistment order.
Where is the para 9?
You also can come to page 28. It starts on page 27, the enlistment letter, para 9, my lord. Wait a minute,
28.
Yes. 9, my lord. I just place it. Please note that MES authority has the right as he may decide not to issue tender from any particular case and to suspend, remove, blacklist your name from the MES listing contractors in the event of submission, my lord. What are the clauses? In the submission of non-bona fide tenders, and it is not a category. For any technical illegal, it is not technical, or other delinquency. But there is no fault on my part. I got the completion certificate.
What is the reason for suspension?
There are no reasons.
Huh?
This is only.
Now, where is the so cause notice? What is the so cause notice they ask for?
Page 45.
Page 45.
Yes.
Yes.
No cause has been given.
Initiated by the CBI coach.
I just, it has been intimated by CBI. If it has been released against your farm, connection with the illegal gratification of some further, it is brought about CBI in the FIR. The case has also been registered against the Nasser. However, from the enlisted records farm, it is noted that farm is a partnership farm having following partners. Please intimate the details regarding. I have given the details based on FIR as referred. A case number has been initiated. In the above, please show cause why your farm shall not be suspended for business dealings. No reason has been given. Para 9 does not attract me.
And the please intimate the details regarding the NASA representing your firm in the work pertaining to the GA Kagdeep.
I have given the reply.
Against Patel, you are the Patel engineer.
Yes, sir.
And NASA for the offense under 120B 789 of the 12.
Can we initiate the officer concerned, myself and that Nasser,
Who is the officer of the
garrison engineer, the MEC,
Yeah.
Ibrahim Ali. He is not arrested, I am not arrested, and he was promoted also. I say that my case is that I have paid to Nasser, but there is no illegal case has not been proved, my lord. But Para 9 is very clear. Para 9, if the Para 9 is the, my lord, it does not apply to me. Submission non-bona fide tender.
I referred about so and so. This dealing with regard to which tender? This FIR has been initiated with regard to the which work?
There no work was given. Mention. No.
Because what is the FIR?
Sorry, man, I should show you. Can you come to page 8? I have given a tagged copy. If you also can, it starts from, my lord, this 41. I have given a tagged copy, contains 42C. Is a type copy. See, Subdev Ibrahim is posted as a junior engineer at garrison engineer and presently officially assistant garrison engineer. Reliable information revealed that Subedar Ibrahim Ali during 22 to 24 entered into criminal conspiracy with Mr. Patel Engineering, represented by his director C. Nasser. Nasser is not in our company. And MES contractor staff and Andrew Island and unknown others in the matter awarding contract for the work or Naval Coast Guard Unit LM matter awarding contract for work and Lakhari in furtherance of the conspiracy. Subedar Ibrahim demanded undue advantage for improper performance of his public duty from Patel Engineering, and Patel Engineering paid illegal gratification to see Ibrahim Ali through the bank account. Nasser, who has MES contractor staff in Andu Island, is revealed from the source information that Patel Engineering is used to send money to bank accounts of the father of Nasser under this guise as they are working from Patel Engineering at Andu Island. Nasser transferred the received illegal gratification to the bank account of wife of Subedar Ibrahim Ali. So it is not in relation to any work. The work I got for that I completed.
Yes.
So my first submission is that luckily I got the 4 works. They give the completion certificate also.
Where is the completion certificate?
Can you see this? I have given out. It starts from 38. 4 works I got it. First work in the 38 at page 38. This is an ability under. No, it starts page 37. Start page 37. This is my work order. Got it, Manu?
Yes.
Then my next page is the completion certificate. Same work, completion certificate.
Yes.
Next, my lord, another work at page 39. This is the completion certificate. This is my 40, the completion certificate. These works I have done. So they have not said in respect to any work. There's no.
Yes, who is appearing for the authority?
It's not my problem.
When you served?
Long days back. And now,
The petitioner has filed the present date application challenging the impugn order dated 19th July 25.
yes,
July 25, now you are challenging this. What
Yes,
is the
madam.
urgency now?
yes, my lord. But this is 1 year, they say, but they said they continue because case is pending.
19 July 2025, wherein the chief engineer, Eastern Command Engineering Branch, had suspended suspended the form of the petitioner temporarily for business dealing with immediate effect for 1 year from the date of the said order. Police. Learned counsel appearing for the petition submit that the petitioner is a registered contractor under the respondent authorities, and whenever the work has been awarded, the petitioner has completed the work with the satisfaction of the respondent authorities, and accordingly, respondent authorities have issued completion certificate. All of a sudden, in the month of February 2020, on 29th of February 2024, the CBI has initiated an FIR against the petitioner and one Ibrahim Ali for the offence under section 120 within bracket capital B, read with section 7, 8, 9 and 12 of the Prevention of Corruption Act 1988 as amended and as amended from time to time. And on the basis of this said criminal case initiated against the petitioner, the respondent authorities have issued the impugn order relying upon clause 9 of the and terms and condition of the enlistment of the petitioner. He submits that the suspension of the petitioner is no way connected with any of the work awarded to the petitioner by the respondent authorities. He further submits that clause 9 of the enlistment terms and condition is not applicable. Is not applicable in the present case. But the respondent authorities, by relying upon clause 9 of the enlistment terms and conditions, has suspended the form of the petitioner for 1 year. 1 year. The petitioner has served the notice to the respondent authorities and filed the affidavit of service. This court finds that the notice has been served upon the authorities, but none appears on behalf of the respondent authorities. Police stop. Admittedly, the petitioner is a registered contractor under the respondent authorities. The petitioner has disclosed 2 work orders and also disclosed the completion certificate, which reveals that the work order which has been awarded to the petitioner has been completed by the petitioner with the satisfaction of the respondent authorities. The respondent authorities have issued the impugn order by suspending the form of the petitioner for participating in a future tender for 1 year, relying upon clause 9 of the enlistment terms and contract, which reads as follows. Page 28, clause 9. Page 28, clause 9. Full stop. In the impugn order, it is alleged that the firm of the petitioner have found guilty of adopting unethical practices. The respondent authorities have relied upon, have issued the said notice on the basis of the criminal FIR initiated by the CBI on 29th of February 2020. As per the FIR initiated by the CBI authorities, the allegation against the petitioner is that the petitioner, along with the petitioner company, along with one Nasser, entered into a criminal conspiracy with Subedar Ibrahim Ali, who is the junior engineer of the respondent authorities, to क्या बोला इब्राहिम अली हाँ हाँ Ali, who is the junior engineer respondent authorities, for awarding contract work to the petitioner. The impugned order does not reveal on which contract has been awarded by the junior engineer by Sri Subedar by Subedar Ibrahim Ali to the petitioner by taking the advantage of illegal bribe. The respondent authorities in the impugned notice have stated that the prima facie it is found, prima facie the authorities have found guilty of the petitioner for adopting unethical practice. This court finds that the CBI only initiated the case and is pending before the appropriate court of law, unless and until it is not decided whether the officer concerned and the petitioner are involved in the criminal conspiracy for getting the award by way of illegal manner. It cannot be said that the petitioner is guilty for the alleged offense. Considering the above, this court find that the prima facie opinion made by the authorities on the basis of which the impugned suspension order is issued against the petitioner is liable to be stayed, and the same is stayed for the period of 6 weeks from date. The respondent authorities are directed to file affidavit in opposition, reply if within 3 weeks from date, 4 weeks from date, reply if any there to be filed within 2 weeks thereafter, list the matter on 24th of March 2026 under the heading adjourn motion.
I serve the notice again, madam. I serve the notice.
Yes, the petitioner is directed to communicate this order to the authority for compliance.
Milord,
Maybe sent to the circuit by the circuit bench.
Let the matter be sent and the record of the case be sent to the circuit bench of Jalpaiguri,
No, the big building we have.
for listing before the appropriate court.
Milord, under grave urgency, Milord, I just missed, Milord. I am praying for 2 leave from your lordship. Milord, this is a circuit bench matter, Milord. The petitioner is the Jalpaiguri Municipality. Milord, the Provident Fund authorities, Milord, has freezed the entire 4 accounts of the municipality. The municipality has come to a standstill. Milord, I am only praying 2 leave, Milord. First leave, Milord, to file the writ petition because your lordship.
From when the circuit bench is
Milord, Wednesday, the municipality can't wait till Wednesday.
yes.
Milord, and Milord, one first leave, second leave, Milord, kindly hears it at 2 p.m. today. Milord, I'll take 2 minutes.
Today it is not possible. Today
Milord, approx 2 crores were the dues. All previous dues, current dues are up to date.
you can-
Almost 80 lakhs have been
there is
paid.
an urgency. Maximum it may be taken at Monday.
Monday,
problem.
Milord, I can wait till Monday, Milord. Kindly, Milord, grant the leave
There
to
is a
file
very-
the writ petition.
Leave
Because
that-
unless
and
your
to list
lordship
Monday
grants
under the Jalpaiguri matter.
grateful, extremely grateful, Milord.
Next, call the matter. File is not there. Yes, right. File is not there. What can be done?
My lord,
What is the last order?
there are no orders passed in this writ.
So 2021, there is no order.
No, my lord. Lord, the
Whether and because it is not in the department, they are searching the file. What can be done? Without the file, how the order can be passed? If tomorrow it is found that that is the defective, then that's why you mentioned it is listed, but file is not there. Department has not sent the file. And 2021, you're telling that then no order is passed. If it is defective, how the court can pass any order in the defect file?
my lord, there is an urgency.
What is the urgency?
Lord, my client wants to participate in a tender, my lord,
Ah,
which is closing today at 2 p.m.
hmm,
And the bid document,
hmm,
my lord, kindly looks at clause 3.29.
hmm.
There is a specific bar of pending litigations.
3.29.
My lord.
Any supplier having track record of 5 years defaulting supplies of debarred for blacklisted. Any legal action SD blocked or any other legal action against them with the government. Against them with the government. Who has filed this writ petition?
The same petitioner, my lord, who intends to participate in the bid.
What is the writ petition for?
This was for an earlier tender, my lord,
What is the writ petition?
to
Blacklisting.
no, my lord.
Ah.
This was challenging the tendering process.
Ah,
Now this workshop is long over, my lord. It has become infructuous.
ah.
But
But
if
where is their file?
uh,
Without the file, where the order can be passed? You tell me. You have a writ petition.
I have it, I am carrying a copy of it.
What can be done? Segregate the price quota. If there is no file, what can be done? The matrix list has to be mentioned by the learned counsel for the petitioner and press for withdrawal of the writ petition being WPA 2045 of 2021. On mentioning when the matter is listed, full stop, it is found that the writ petition is not traceable, and as such, it was not placed before this court. Accordingly, learned counsel for the petition has provided the copy of the writ petition. Full stop. The department is directed to reconstruct the file. Counsel for the petitioner submitted the petition is not intending to proceed with the matter. Proceed with the WPA number 2045 2021. And he further submit that unless and until the petition will not withdraw the said petition, the petition will not be in a position to participate in any tender. Which department?
My lord, this is the Madhya Pradesh jute. This is for supply of gunny bags.
Which department?
My
You are not having knowledge that also.
No, my lord. After copy.
Any tender in the state of Madhya Pradesh, in the Department of Civil Supplies.
My lord, Madhya Pradesh State Civil Supplies Corporation Limited. My lord. That
In
is
the Madhya Pradesh Steel Civil Supplies Company Limited. And accordingly, he prays for withdrawal of the writ application. Is the petitioner?
the authorized officer, my lord. My lord, I am also
Submission
carrying
made by the
instructions.
counsel for the petitioner.
About
You have a
rectification.
written instruction?
Yes, my lord. Authorized.
You have a written instruction for withdrawal?
Yes, my lord. You know, the extracts of board meeting and
The petitioner has placed the extract of board meetings and the instruction for withdrawal of the instant date application. Let the same be kept with the record. Consider the submission made by the counsel for the petitioner and the board meeting and the extract of the board meeting and the written instruction WPA 2045 2021 is dismissed as withdrawn. Interim order, if any, is passed. Is hereby vacated.
So grateful, my lord.
Next,
So grateful.
reconstruct करके उसको भेज दो.
12টা নাগাদ হবে। But the point arose not whether 226 or 227 will lie from an order passed by the maintenance tribunal. But to assist your lordship, your lordship will kindly see the single judge's bench relied upon a division bench of this honorable court, which did not deal with the issue as to the maintainability of 226 or 227. But your lordship will kindly have a look at. But MAT 61, I think the judgment was handed over on the last occasion. Oh, it was not. Very well. Your lordship may kindly have a look at paragraph 90. And the single bench.
Yeah, this court, the division bench are left over to the
Very well.
this court. So decide whether it is 226.
Now,
or
my lord, I
227.
answer your lordship, my lord, with reference to, my lord, a division bench of Delhi High Court and a Supreme Court, which says that, my lord, in respect of a judicial order, only 227 will lie. But others may be covered under 226. And my lord, the division bench.
This WP is disposed of only on the basis of this.
Yes. The learned, my lord, the single bench here, my lord, was of the opinion, my lord, kindly see page 3. In view of the above, the application is disposed of by granting liberty to the writ petitioner to move an appropriate application under 227. And Lord, the other page, page 2.
No. So court has recorded by an order 19 March, the appeal was disposed of, remanding back the matter to the single bench with an observation that an order of the tribunal cannot be challenged by way of an application under it.
And thereafter, my lord, the single judge, my lord, at page 2, last paragraph held that lord, the division bench held that it is not maintainable. So, my lord, it has become abundantly clear that an order passed by the learned tribunal under maintenance and welfare.
That has not been decided on merit whether it will be 226 or 227.
Yes. Now, my lord, then, Lord, I assist your lordship by reference to, my lord, a division bench of the Delhi High Court, which squarely deals with the issue. Lord, with reference to, my lord, the Supreme Court judgment, which I have also brought, my lord. Lord, will kindly come to paragraph, my lord, 9.2. Lord, it starts from paragraph 9, and thereafter, my lord, the 9.2. Then 9.3.
The scope of
and it is
jurisdiction-
both under 226 and 227, depending on the nature of the order. Oh, maintenance tribunal. এখন যা আছে maintenance tribunal. দে পাওয়া দে। I am not inclined, but on insistence. ঠিক আছে। তুই তার থেকে রাধেশ্যামটা দে আমাকে। রাধেশ্যামের প্যারাগ্রাফ কত? পড়তে আরম্ভ কর।
আচ্ছা, same maintenance tribunal.
Maintenance tribunal. This is a judgment from maintenance tribunal.
Certainly amenable to the jurisdiction. Yes.
And Lord, this judgment relied upon Lord the Supreme Court, a 3 judges bench, Lord, which at paragraph Lord paragraph 27, Lord, it says that only judicial orders are Lord to be subject to Lord Article 227 jurisdiction. Paragraph 27. Yeah.
dealing with the scope of 226 and 227 and the comparative scopes.
The same which
The
the
same, Lord,
reiterated.
and the division bench of Delhi High Court considered this judgment.
reiterated that. Yes.
And my lord, another single bench decision of this honorable court held that, my lord, it can be amenable to writ jurisdiction. Paragraph 11. Oh, this is a maintenance tribunal matter. আর কিছু আছে? That was considered by the 3 judges bench, which is this. Honorable.
Yes.
That's all.
I have one, my lord, which relying upon the Supreme Court decision cited by my learned senior friend, has held that
227.
on the same, relying on the same Supreme Court decision. Just to confuse my lord a little bit, but as an officer of court, I think, my lord, certiorari will lie, but the scope is narrower. This has been my lord will note that it relies on the same Supreme Court decision, 2015-5 SCC 423. And this was not referred to in the decision cited by my lord, my learned friend, the decision of Justice Shampashar.
But the latest judgment is prevail.
This has not referred to the earlier one.
Maybe, but this latest judgment will prevail.
If it refers to the earlier one, we can go on and on. But the proposition of law, my lord, kindly sees 447 of the Supreme Court report, Radheshan.
Yes.
That the scope in 226 is narrower, but 447, page 447.
Paragraph.
There's paragraph 24 towards the top of the page. The 4 lines above that. Lastly, the jurisdiction under Article 226 is capable of being exercised on a prayer made by or on behalf of the party aggrieved. The supervisory jurisdiction is capable of being exercised suo motu as well.
Appropriate High Court while exercising supervisory may substitute its decision on
Not the first 4 lines. I'm reading from the 5th line from the top.
its
Here, my anxiety is that this 25,000 has not been challenged. So, in 226 jurisdiction, my lord exercising suo motu jurisdiction cannot, my lord.
No, that's why. Which is not challenged, the court cannot
Yes, but
interfere with
it
that.
could have done. It could have been done possibly in 227. That is what is said here.
No, with regard to the two-turn, which is not challenged, that the court will decide.
Yes.
No, only the main question is because whether it is a
No, certiorari has to lie. Otherwise,
226 or
The
227.
ouster of jurisdiction
Because
of a constitutional court.
Mr. Mukherjee has fairly submitted that he is not on the quantum of the amount, though 15,000 is not quantum of the amount only with regard to the landed, the vacating of the
Yeah.
property.
the interpretation of these 4 lines would be in 227. My lord could have suo motu reduced that. Mercifully,
Okay,
it's a 226, not 2.
let
And the other thing, my lord, even if my lord interferes with that ouster order, but in case of default, but the liberty has to be reserved to the
that always.
client.
That is there under the
That
statute.
always
Lord,
under
he
the
has jumped,
statute,
Lord, the forum
because
under the
now,
statute.
see,
before.
the Supreme Court has also considered with regard to the 23, you have a liberty. If they have violated, you can take appropriate steps, and the
Yes.
authorities has the pass an order, whatever you prayed for.
But
before.
this is not a case under 23 at all.
It's not
this
at all.
2025 Supreme Court decision
Yes, yes.
cited, that also my lord, reiterated that in case of violation, harassment,
Correct. That's what I'm telling. 23 violation found. So whether in the That the authority will do once the that occasion arises. Thank you.
Grateful.
For the
Much obliged.
the learned counsel for the parties have appraised before this court with regard to the point whether the against the order passed by the maintenance tribunal, whether the
कानून का point है
application under 226 or
हाँ,
article 227
Yeah,
which lie. Here lie. Hearing concluded, CA.
Apart from the Kanun ka point, the paisa wala, the January money didn't come in
Okay,
January.
why?
I told him that ये कानून का point है आपको कुछ बोलने का नहीं है.
But
That is the
paisa
only
ka
thing I
matter,
said.
January money hasn't come.
Pay. Why आपके पैसा क्यों नहीं दे रहे हैं?
February 3rd, before the
पैसा कब दिए?
in February, on February 2nd.
February
The
का
entire month went without payment.
दीजिए फिर आपको प्रॉब्लम हो जाएगा.
And the other more difficult thing is the reimbursement of medical expenses. So that is a very, very challenging thing.
Next week it will tell you.
Obliged.
Much
Thank
obliged.
you. Next.
Oh, Lordship, I'm for the state.
Yes.
The petitioner, my lord. And on the last occasion, my lord has extended the interim order till 6.
Hmm.
So that's why.
Who is for the respondent?
Lordship, I'm for the state, but clinical established, he's there.
Ah. What is the can 2? Can 1, can 2. What is the can?
And
Restore the petition in original form. Restoration.
Restoration, my lord.
What restoration?
It was dismissed for default.
Which one? Writ petition.
The writ petition.
So writ petition is dismissed.
Once it was dismissed.
So it
for
was
default,
already
it
disposed of.
Restored also, my lord.
restored also.
Okay. So what is the writ petition for?
My lord, it is for this. I'm just wanting the stay upon the order passed by the learned clinical authority, my lord.
No, that's correct. But how for the mistake can we continue? Whether you file the affidavit?
No.
So
Affidavits have not been exchanged. Lordship, I'm not the
without
Lordship, I'm not the answering respondent. The establishment is.
We do not have any document to produce before your lordship.
So I can record that you will not use any affidavit. So I am fixing it.
Whatever is there in the
What are the
petition,
document you are relying upon the document and you argue the matter on merit. Correct.
Yes, ma'am.
My lord, I'm
And
like,
one
So
more.
they are telling that they will not rely upon any, they will not file any affidavit. They will rely upon document. So I am extending it. I am fixing another date so that I can extend the interim order.
One humble submission, my lord. The the presence of the private respondent is necessary, my lord.
Hello, we have served. If they are not appearing, what can be done?
They have chosen not to appear.
If they are not appearing, but after the restoration, have you informed?
Yes. Repeatedly, we have.
The matter is listed as to be mentioned for extension of interim and is listed for extension of interim order. Counsel for the petition submitted, the interim order is still today and paid for extension of interim order. The respondents submitted, they will not use any affidavit and they will rely upon the documents available relied by the petition in the writ petition. Accordingly, chance to file the petition of opposition is closed. Accordingly, this court find accordingly as per the submission made by the counsel for the respondents, this court find that no necessity for giving any direction for affidavit in opposition. Let the matter appear on 24th March 2026 under the heading urgent motion. Interim order is extended till 25th of March 2026 or until further order.
Obliged, my lord. Grateful.
24th March 2026.
Next.
Grateful.
So this is the application Malad, for extension of interim order. It has been extended from time to time. The last order Malad, is at page 17.
Existing since March, May 24.
And Malad, the order interim order was passed Malad, on 24th May 2020.
In presence of, in their presence. And after hearing.
I should have done.
Not that an expert here.
What is the can extension?
Yes, Malad. Can is Malad the extension. Can 7 Malad is the extension. First order Malad is
Who is for the authorities?
page 9 Malad. Bank is.
Huh?
UCO Bank.
What is the matter?
Malad, this is Malad with regard to Malad challenge to notices Malad, which are on the face of a time bar. Malad, which were issued 2015 Malad, The cause of action. The,
Affidavits completed.
no, my lord, affidavit, they're still not filed affidavits.
Affidavits are not.
Will
yet-
not file.
Yes, your lordship, we will file.
How soon?
The draft has been sent to the bank official.
Ah.
It is yet to be affirmed, your lordship.
How much time you required?
2 weeks, your lordship.
2 weeks you will file?
Yes,
Sure. No extension.
It's been, my lord, extended and extended, my lord, so far as, my lord, they are concerned.
The matter is listed for extension of interim order. Fully counsel for the petitioner. And petitioner has filed an application being Can 7 of
Kindly
2026
give them, my lord, a longer time, my lord.
for
and then, my lord,
praying for extension of the interim order. Extension of the interim order. Learned counsel for the respondents prays for extension of time to file affidavit in opposition in the main date application. Let affidavit in opposition be filed within 4 weeks. Reply, if any, there to be filed within 3 weeks.
3 weeks.
3 weeks. List the matter on 2nd April 2026 under the heading adjourn motion. Interim order is extended till 7th April 2026 or until further.
7th April.
April 2026 or until further order.
My lord, can it be till end of April, so that, my lord, we don't have to, my lord, trouble my lord during that vacation, my lord, that.
Before vacation.
If it's extended, my lord, then we don't have to come back till 30th April and, my lord, it can.
Now, I have fixed on 2nd April as adjourn motion. 2nd April adjourn motion and extended till 7th of April.
Lord, instead of 7th, my lord, can it be a little later, my lord, if it's not
Is extended till 17th April. 17th April.
Very good.
Or until further order, whichever is early.
Great.
Can is disposed of. Can 7 is
Great.
disposed.
Can 6 is also appearing, that's already disposed of. Not Can 6
it
is the but that's already disposed
It is fine from the record. The Can 7 is already disposed of.
6, Can 6 is.
6 is already disposed of. Accordingly, Can 6 be delisted from the list? ठीक है जी?
7
Next.
आज के 6 already disposed.
I'm grateful.
Happiness.
Lordship, my application for Can is for the restoration of the writ petition.
When it was dismissed?
It was dismissed on 36/2025.
36. Why it has been dismissed?
Uh,
Why you not appeared? Why the
Lordship-
petition has not appeared, madam?
Lordship, I have stated in the paragraph number 2 and 3 that
Monthly list, but the clerk of the unfortunately missed the note. Correct. What is the matter?
Lordship, this writ was challenging the order of the RTI.
Huh?
RTI application I have filed before the respondent ban, and they have not replied yet.
Where is your application under Right to Information Act?
Lordship, page number
17.
17.
You are given to the Deputy General Manager.
Lordship,
So they are not provided.
they have not provided. I have gone for the appeal also.
Appeal also you went. Where is the appeal? 18.
18. Lordship.
Appeal is also pending. Appeal not decided.
Appeal also has been decided, but they are not provided.
Appeal?
Appeal has they had not provided the details yet.
No, no. Appeal. Where is the appeal order? Appeal decided or not?
Uh,
Already there. Kindly see the page number 20. What is the page number 20? Regarding your appeal under RTI. Information related to third party cannot be shared with the anybody. However, you may visit the branch and fulfill necessary requirements in order to receive the desired information.
The petitioner is not the third party. The
Huh?
daughter of petitioner is not the third party. She is the daughter of the
So you went to the commissioner also.
Lordship.
Kakali Ghosh, you are the petitioner. So you went to the commissioner also. Kindly come to the 21. What is the order of the commissioner? Commissioner, the commission after adverting the consequences and hearing the parties on perusal record observe the reply provided by CIPO to the appellant requires no intervention. Further, as advised by the CIPO during the hearing, the appellant is liberty to submit the requisite document for assessing the information rate. Yes, what remains? What
Lordship,
remains? Kindly come to the prayer. Your prayer is something else.
Lordship, kindly provide,
Huh?
allow some time for the hearing.
No, 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 no. Nothing else. Nothing remains. Kindly come to the prayer. Commanding respondent want to provide the details information as sought for by the petition under Right to Information Act 8 January. After the 8 January, the appellate authority has passed an order on 10th of January. So what remains? Record. The petitioner has filed the present application being Can 1 of 2025, praying for recalling of the order dated 30th June 2025, wherein this court has dismissed the writ petition for default for non-appearance of the petitioner when the matter was called. Counsel for the petition submit that on 30th June, the matter was listed in the monthly list of 30 at serial number 481 on the monthly list on 30th June 2025. But the but the clerk of the learned advocate inadvertently could not take a note of the same, and due to which the learned advocate appearing for the petitioner not able to appear before this court, and the matter was dismissed for default. Had the learned counsel for the petitioner perused the application, this court find that sufficient reason has been shown for non-appearance of the petitioner. Can number 1 of 2025 is restored, is allowed. WPA number so is restored in original file. Full stop. This court has taken the writ petition for hearing and hearing on merit. This court finds that the petitioner has made a prayer directing the respondents number 1 to 4 to provide detailed information as sought for by the petitioner under Right to Information Act through an application dated 8th of January 2024. Full stop. This court finds that on 8th of January 2024, the petitioner has made an application under Right to Information Act to the Deputy General Manager and CPIO for providing certain information. The Deputy General Manager has not provided the same. Accordingly, the petitioner has preferred an appeal before the appellate authority, that is the Zonal Manager, on 3rd of March 2021. The Zonal Manager has disposed of the appeal filed by the petitioner, holding that the account number, total numbers of FD, and the amount lying in the account of late Dilip Kumar Biswas at Rathu Road branch. We wish to inform you that the appellate authority has passed the following order. Page 20, last paragraph. Set out. Being agreed with the order passed by the appellate authority, that is the Zonal Manager, the petitioner has preferred a second appeal before the Commissioner. The second appellate authority is also disposed of the appeal preferred by the petitioner by passing the following order. Paragraph page 22, paragraph 7. Full stop. Considering the above document, this court finds that the application filed by the petitioner was duly decided by the first appellate authority as well as the second appellate authority, and thus there is nothing remains in the present writ application. WPA number so and so disposed and dismissed. Next.
My contempt application on the previous occasion. Millard had adjourned this matter for my learned friends to take instruction.
Yes.
At the very outset, I am submitting paper, Lordship. Your Lordship last occasion directed to take instruction.
Yes, yes.
I got the instruction. I am submitting before your Lordship. Number 2, Millard, the copy of the contempt application, that is the procedure of the court, that has not been served to me or the department. That has been done. And MA application is also filed. That was not heard by your Lordship for vacating the window. That your Lordship knows the Supreme Court says also, in case of SOP, Millard,
That's why yesterday I told
Your
you,
Lordship can see.
with regard to vacating officer, this court will take, because both the, I have fixed when the matter is fixed.
Fixed for, on
Then
7th
why-
of March.
7
Lordship
March
can-
it is fixed, correct.
Your Lordship
But,
can see.
At my lord's, at my
but
learned
rightly and wrongly, there is an order of stay. You have to comply unless and until the,
No,
if
in-
the Supreme
in
Court has
case-
not stated that
Of course,
without
not that, my lord.
Please hear me that Supreme Court has not stated that without complying the order, you file a vacating application and you're not required to comply with the order.
Yes, I am submitting.
Yes.
Yes.
So,
Yes, your
Show
Lordship
me.
can see it.
you're not required to comply with the order.
No, no question of complaint. Your Lordship can see the first.
Yeah.
4.2. 4.1.
Which
And-
judgment my learned friend is citing?
Here it is. Civil appeal number such and such. Supreme Court Employees Association, my lord, or Lordship knows. Uttar.
Yes, correct.
Yes. Your Lordship kindly sees the instruction. I want to file in the form of report, my lord, by affidavit. What is the difficult for us?
Okay, you file affidavit. I am issuing the rule. You file an affidavit.
Your Lordship kindly sees the
Yes, I have
instruction.
seen. I have seen.
Instruction.
So, act of your authority shows that you are not inclined to obey the
No.
compliance of the order, interim order passed by this court.
No,
You
what is
file
the-
whatever
your Lordship
affidavit,
kindly
record
sees
an order.
what is the instruction.
Record an order. This court by an order dated. This court by an order dated 3rd December 2025.
4.2.
No, my lord, 3rd December
3rd December
2025.
2025 pass an interim order,
Affidavit of
interim order,
vacating of
restraining, interim order, staying the impugn order dated 26th of September 2025 till 7th of January 2026. And the respondents are directed to allow the petitioner to continue with the business till 7th of January 2026. This order was passed in presence of the learned advocate appearing. This order was passed after hearing the learned counsel appearing for the respondent and in presence of the learned advocate appearing for the respondents. Subsequently, the matter was listed on 7th of January 2026. And the learned counsel for the petitioner has prayed for extension of the interim order and also submitted that the respondents have not complied with the interim order, passed by this court by allowing the petitioner to continue the business. Full stop. The respondent, the learned counsel appearing for the respondent submit that the respondents have filed an application for vacating the interim order being Can 1 of 2020.
on 18/12, let it be recorded. Can 1.
Well,
18/12.
1 of 2025. And the petitioner has filed an application for petitioner has filed a contempt application being CPN 2033 of 2025. CPN 2033 of 2025.
2025.
The matter was again taken up for hearing on 28th of January 2025. Again, the petitioner has complained that the respondents have not complied with the interim order. And this court has fixed the contempt application on 4th of February 2026. On 4th of February 2026, learned advocate appearing for the respondents prays for time to take instruction. Accordingly, matter is fixed today. When the matter is taken up for hearing today, with regard to the contempt application, the respondent number, the learned advocate appearing for the respondents has relied upon what is the judgment? What is the citation?
Citation. And also, kindly consider the instruction I reported below. The policy matter, is going on. That's why,
Sir, policy you can take. Court has passed an order.
The development of your Lordship kindly says the Amrit Bharat program is a non-payment of the if the
क्या बोला? Has relied upon the judgment passed in civil appeal number 23-24 of 2024, comma, special leave to appeal number 8575-8576 of 2023, State of Uttar Pradesh and others versus Association of Retired Supreme Court and High Court Judges at Allahabad and others, and submits that, and relied upon paragraph 4.1, which reads as follows.
1 and 2.
Ensuring compliance with judicial order involving intricate policy matters necessitates navigating various levels of the decision making by the government. The court must consider these complexities before establishing specific timelines for compliance with its order. The court should acknowledge and accommodate a reasonable time frame as per the specific case species of the case. 4.2 states that if an order has already been passed, comma, the government seeks a revision of a specific time frame, comma, the court may entertain such request and permit a revised, comma, reasonable time frame for the compliance of judicial orders, comma, allowing for hearing to consider the notification, comma, close. The petitioner and the respondents also handed over the written instruction issued by the senior commercial manager dated 6 February 2025, wherein it is mentioned that the Kharagpur and Baleshwar railway station is under development of Amrit Bharat program. Due to this reason, railway administration has not complied with the Honorable High Court order dated 3rd December 2025. The petitioner has also full stop. It is also stated that the petitioner has also not paid the outstanding amount of rupees 11,78,707 for 3 stalls, 6 trolley and 1 table till the period of 2/10/2025. It is also stated that the full stop. Had the learned counsel for the parties perused the instruction and the judgment relied by the petitioner. Judgment relied by the respondent. This court by an order dated
3rd December.
3rd December 2025 has categorically stayed the operation of the order dated 6th of September 2025. And the interim order is still continuing. The respondents are participating in the present writ proceedings. Admittedly, the respondents have filed an application for vacating, and the same is fixed for hearing on 9th of March 2026. But from the written instruction issued by the senior commercial manager at serial number 2, he stated that the Kharagpur and Baleshwar railway station is under development of Amrit Bharat program. Due to this, railway administration has not complied the Honorable High Court order. But the reason which the petitioner respondents have assigned, that is not the reason of cancelling the passing the impugn order. Dated, what is the date?
26 September 2025.
Dated 26th of September 2025. 26 September 2025. Only to avoid the compliance of the order, now the respondents have taken the steps. But whether the railway station is working?
Yes, Milord. My stalls are still there.
Police, other stalls are there?
No, this other vendor stalls are also there.
Police.
Everything is there.
And whether this railway station is in a working condition?
Yes, Milord.
Police. Counsel for the petitioner submit that the other stalls are also there and they are functioning, and the railway station is still functioning, but only the respondent authorities are not allowing this petitioner to run the business in spite of the interim order passed by this court. According, this court find that the respondent authorities have willfully and deliberately violated the order passed by this court let the rule be issued, returnable on, आज कितना तारीख है?
Today, my lord, we are on 6th.
Returnable on 13th of, not 13th. Where is the office?
Well, Kharagpur, the Sendhi head office.
Returnable on 13th of February.
Should be served today.
Returnable on 13th of February 2026
MDPU
for
by.
personal appearance of the respondent.
MDPU by.
Copy of the contempt application be served to me.
Yes, yes. With the rule it be served. And then with regards to my learned friend's issue of non-payment, I have dealt with in my affidavit.
I'm here.
MDPU pledge.
Sorry, my lord.
Item number 81.
Yes, where is your instruction?
The matter was settled, my lord, and I am instructed not to proceed.
Record an order. Though the matter is listed as item number 81 of the today's list, but the learned counsel for the petitioner submit that he has got the written instruction from the plaintiff, wherein the plaintiff has informed the learned advocate that the plaintiff is not interested to proceed with the case. Accordingly, the counsel for the petitioner prays for withdrawal of the case. At the learned counsel for the petitioner perused the communication dated 2nd February 2026, WPA number 27293 of 2025, Zakir Hussain Mandal versus State of West Bengal and others, is dismissed as withdrawn. Interim order, if any, stand vacated. Communication be kept with the record.
The written instruction be kept with the record. Grateful, my lord.
Next. My lord, I am appealing from the respondent, my lord. Before placing the matter, my lord,
I am raising the point of maintainability, my lord. Last question, Lordship, please to, on 3rd December 2025, Lordship, please to pass an order by keeping the point of maintainability open, my lord. Lordship, may I?
Who is for the petitioner?
I am for the petitioner. For the paragraph 5 and 6, my lord, they have stated wrong statement, my lord. Wrong statement said by the. Let them satisfy the point of maintainability, my lord.
What is the application? Where is the application? Listed? Today listed?
Allowed হয়ে গেছে allowed হয়ে গেছে
Item number?
allowed হয়ে গেছে
Item number 12.
that was allowed
Application.
that
When
was
you file the application.
that was allowed, I've seen. No, that has not been allowed. It never been allowed.
Application.
এদিকে আসুন।
Your application is not listed, sir.
That is in the file, my lord.
In the file.
Yes, yes. On the
স্যার,
earlier
আপনি আসুন না
নাম্বারটা বলুন বলা যায়
এই তো,
application first.
Can?
can one
Can one, yes. Who has filed this application?
আরে
Who has
নামটা
filed?
চন্দু কিসকু
So I am of this property.
Okay.
The land is not vested to the state government. Instead of that,
Okay,
all land has been settled.
Okay, I will take care of it. Yes.
Lordship, my only point of maintainability, let them satisfy, my lord.
Yes, what is the mentality you raise?
Lordship, kindly come paragraph 5, my lord. Kindly come paragraph 5, my lord. They have stated wrong statement, my lord.
Paragraph?
5, my lord. 5 and 6. May I please, my lord?
Paragraph 5.
Lordship. May I please, my lord?
Yes.
The respondent one through the Department of Commerce and Industries, by its letter dated 6th December 2010, allotted an area such and such, my lord, and an area of such and such, my lord, both under police station Mohammed Bazar within district Birbhum to the respondent 4 for the purpose of Blackstone mining, my lord. Thereafter, pursuant thereto, the respondent 1 has granted a mining lease in favor of the respondent 4.
You are appearing for whom?
I am the private respondent, my lord. This is the wrong and false statement, my lord. Let them satisfy this point, my lord. No lease was granted by the government,
So
Lordship.
if it is not granted,
Lordship.
so if at the time of hearing it is found that it's not, where is the mentality point? If
Lord-
this court find that he made a suppression of the fact that it will be dismissed, where is the point of
This is,
mentality?
Lordship, this is the basis, Lordship. May I speak?
Correct.
Lordship.
He has made a government.
Lordship.
And you have opportunity to deal with that. If this court found that this what they have made, and you are denying that there is no no document, no allotment, no agreement.
Lordship.
So that will a suppression of fact. That will be where is the point of maintainability?
Lordship.
May I say this thing? I understand what your lordship is indicating. Only thing I say that I find, Milan, that this point was agitated at the time when the matter was taken up. Lordship indicated that your lordship is keeping the point of maintenance open, but now your lordship is going to decide the main merits of the matter. Therefore, Miller, this matter is not of that substance as it falls for my lord kind consideration. But one thing your lordship may kindly consider, that the report which was filed by the state, your lordship asked them, Miller, to file the report. Now the reports, Miller, clearly indicate that so far as my clients are concerned, they had, because there is an allegation that my clients are extracting Blackstone. There is nothing on that so far as the allegation is concerned. Now, Milord, then Milord, I will permit Milord the writ petitioner to make the submission. Then I will be making my submission. Correct.
This is the basis.
ঠিক আছে আগে জোসেফ তো
Then let them settle.
পিটিশনার কে শুনবে আমরা আগে বলছি কেন ওই তো এটাই বুঝতে পারছি না আমরা আগে কেন বলছি
ওগুলো মেইনটেনেবল পয়েন্ট রেজ করছি কোডগুলো তাহলে তুমি বলো কি মেইনটেনেবল হাউ
না এটাই তো বেসিস এটা যদি না থাকে তাহলে সব রিপিটেশন থাকবে না রিপিটেশনটা
Who is for the state?
I'm for the state, Malad.
Yes.
Joseph,
On the last
should be
occasion, you have taken time for taking instruction. Yes. What?
I have taken steps.
So may I reference your lordships regarding your lordship the matter about once?
Just a minute. Let me first. Can it dispose of?
সেটা বলুন সেটা স্যার বলুন
যদি না থাকে
Only one thing should I add, if your lordship permits me, Milord. On instructions from my instructing advocates, Milord, that there is no agreement to the effect that I have obtained the lease. I means the petitioner had obtained the lease. Therefore, if there is no such agreement on the face of record, then the entire matter, Milord, falls down. That I should, no, Milord, I must not make any more submission. ठीक আছে बोलो तो
Hey, when they considered me disposal दिखा था, can one? Huh? नहीं, तीन बार.
Specifically by no order it have been disposed of, Malad.
Have you filed the reply to the can one?
No, yes, sir.
Have you filed the reply to the can one?
No.
So the order date the 3rd December. They filed the affidavit in opposition. You take time for the filing reply. Where is the reply? Yeah?
I am not finding the.
So you are not stated that he will not file on the, because 13 December order record the applicant press for time to file reply.
I have not filed it, but my record will show that I have got the right in respect of this property. Land is not vested to the state government. I have annexed the.
Who are you?
I am the owner in respect of this property. I am the owner.
This property, no? Your property
It
to Malik,
was
no?
not-
But this was the नहीं है.
Property মানে total
Not all. আমার application টা গেল কোথায়? এখানে ছিল তো।
Yes.
He is the owner of certain plots of
No,
land.
there are two things they have raised the objection. One is
yes.
with regard to the paragraph 4 and 5 and with regard to the lease agreement. Whether that these are what are,
May I indicate your lordship?
what is the locus?
Yes, locus. If your lordship kindly sees, tender was floated. I participated in the tender, and your lordship, I had been declared as a successful bidder in connection with the tender floated by the West Bengal Mineral Development Corporation.
Correct.
I need to only show the documents and the agreements. Lordship, kindly take page 25.
25 is the tender.
No, page 25, yes, your lordship, is the tender grant.
Correct. Grant of long time.
Now, your lordship kindly sees who has issued it. Government of West Bengal in favor of West Bengal Mineral Development and Trading Corporation Limited.
Correct.
Dated 16th of December 2020 to 2010.
Correct.
Subject is grant of long-term mining lease for Blackstone to WBMTC Limited in Mouza, Hadgacha and Jetia.
Yes.
JL number such and such.
Yes.
Sir, I am directed to refer to your application dated 9th of January 2009 and on the subject mentioned above, and to state upon that upon due consideration, government has been pleased to order that a mining lease for Blackstone in respect of under the above mentioned area for a period of 20 years shall be granted provisionally to you on your
So it
complaint.
has been granted to the West Bengal Mineral Development
Corporation. Now,
Correct.
who am I?
Yes.
Kindly take page 43.
Page 43.
Page 43.
Yes.
Page 43 is the letter dated 16th April 2013. AVN Overseas is my earlier name.
Yes.
Page 43, left hand side.
Yes.
West Bengal Mineral Development and Trading Corporation Limited is issuing a letter to AVN Overseas. My earlier name now is IRC Naturals Limited. Now, Your Lordship, kindly see subject e-tender for exploration, mining and supplying of Blackstone from Hadgacha Blackstone deposit and Hadgacha Jetia Blackstone deposit at district Birbhum. Now, sir, in respect of the above, we are pleased to inform you that as per your online financial bid, you have selected for both deposits, that is Hadgacha Blackstone deposit and Hadgacha Jatia Blackstone deposit at district Birbhum under the above e-tender. So I had been declared as a successful bidder. Thereafter, all formalities I have done, given the performance bank guarantee and everything. Now, Your Honor, kindly, Your Lordship, kindly come to page 46. That's the mining agreement.
Yes, that's that. Let you satisfy this. So this is 46.
Page 46,
Yes.
and we also executed a supply agreement, another mining agreement, that is at page 68. There are two. One is page 46 is Hadgacha and page 68 is Hadgacha Jatia mines. Both mining agreements we have executed. Page 46 and 68.
Yes. Then
Thereafter, Your Lordship, we also
this agreement is valid up to what? Which date?
Lordship, there is no time period given. Time to time, Your Lordship, we extract the minerals. We basically hand over to the West Bengal Mineral Development Corporation and they sell it to us. That's, Your Lordship, the entire MDOP structure. Now, kindly take page 104, because what happens whenever West Bengal Mineral Development Corporation gives, Your Lordship, mines to the bidder, we have to basically develop the mines. We have to prepare the roads. We have to do other activities in the mines, and then after the supplies can be done.
So what is the schedule of property? What is the survey number?
Yes, Your Lordship. Total area is 179 acres of land. Lordship, kindly take page 46. Lordship, kindly take page 47, paragraph 3. Page 47, paragraph 3. The government of West Bengal, through its Commerce and Industries Department, with a letter dated 25th of February 2011, has allotted an area of 108.53 acres at Moza Hadgacha, PS Mohammad Bazar, District Birbhum, to WBMTC for the purpose of Blackstone mining, pursuant to the West Bengal Mineral Development Corporation, will be granted a mining lease for the said lease period by the government of West Bengal for a period of 20 years, which may be renewed or extended for further periods subject to necessary approvals of the government of West Bengal.
Yes.
So this paragraph is there. Now kindly take page 69. 108 acres is there. And now kindly take page 69.
Which is the survey number? What is the survey number? Because they are claiming with regard to the survey number. What is the survey number of this? This area is 108.53.
That, Your Lordship, will grant.
What is the survey number? Plot numbers.
If Your Lordship kindly sees once, the schedule of the plots are mentioned in the grant order. Lordship kindly sees first, take page 25.
20?
Page 25,
yes.
the grant order.
Yes.
And there is a schedule there.
Yes.
Page 32.
Shall be.
Annexure 1.
Shall be.
Page 28.
Page 32.
No, Lordship, page 28.
28.
Page 20, I'm sorry.
ট্রেডিং কোম্পানি পেলে তো সে দেবে
Schedule.
This is
So these are
Hadgacha
the
Hadgacha JTI is 25 and 28 and 29 kindly sees. This is only for Hadgacha and the schedule is at page 32.
So this is the 1506 to 1660.
Yes.
And here is 146 years. So these are the two properties. These are the properties.
Yes. And thereafter another grant was again renewed. That is at page 33 and 35. All the details of the properties, everything given. Page 33 and 35 kindly see. And this is issued sometime in the November 2018.
Yes.
So there is no difficulty in respect of your lordship, the title from the government to West Bengal Mineral Development Corporation.
Which
thereafter to be-
survey number you are relying upon? What is the survey number? What is the plot number?
Plot number, yes. My lord, our plot number is, my lord, you have to kind of. Our plot number is.
They indicate what has happened. There are two sets of people there.
Yes.
One is the
Our
that's
plot
why.
number is, my lord, 1252, 1253, 1254, 1255, 1256 of Mauja Hadgacha.
Moja?
Mauja Hadgacha.
Adgacha.
Yes, there are two Mauja Hadgacha and Jetia.
Yes.
Yes.
That is not the property here.
Yes,
But-
yes,
yes.
Your Lordship kindly come.
28.
Yes, yes.
These are
Your Lordship
the
kindly come.
plot number under Hadgacha Mauja.
Yes. Your Lordship kindly come page 32.
Yes.
Just one minute. Have Lordship got it, my lord?
Hmm.
Now, schedule of land, Mauja Hadgacha. Your
Hmm.
Lordship kindly see plot number 146 onwards.
Ah.
Now, second line,
Ah.
1252, 1257.
Ah.
Within that, my lord, we have got the land.
Ah. You are the
Yes.
you are the owner.
I am
Where is-
the owner.
Where is the document?
I am the owner.
Where
Yes.
is the document?
Oh, yes, addition of party, Your Lordship kindly come. And I have also made an application for whether the land is vested or not. Under the RTI Act, they have supplied that no, it has not been vested to the
Where
state.
is your mentioned in the
Lordship.
can application?
Yes,
Can one?
yes, can one. Yes. I have annexed, my lord, it is Bengali. My lord, record of right, page 14.
Hmm.
That is in Bengali.
Hmm.
My lord, plot number 1252.
Hmm.
Next, Your Lordship kindly give some. 1253. Have you not got it?
Yes. Who is for the state?
For the state,
Now,
Yes.
now
What
Your
is the
Lordship kindly just
what is the
complete.
contention?
Only one interruption can I make? One. We had for a second. Page 25 can we come? For a second. Page 25 of the deed petition.
Yes.
Lordship has seen, Milord, this long-term mining lease. Now kindly come to the first three lines. This is issued by the Joint Secretary to the Government of West Bengal. I am directed to refer to your application dated 9/1/2009 on the subject mentioned above and to state upon due consideration, government has been pleased to order that a mining lease for Blackstone in respect of the undermentioned area for a period of 20 years shall be granted provisionally.
Correct.
That is the document that it has been granted. This will.
So that's why I'm asking what is the state?
This has been echoed also in page 29.
What is the state?
But the process is this, will not the government asks the corporation to use the land through its Milord. The corporation issued the Milord agreement or the permission
Hmm.
to the through the bid, Milord.
Hmm.
And this process the petitioner before your lordship has being the successful bidder are using. Milord, the land, your lordship kindly visualize the upper portion of the crust
May I
of the
give
land.
the answer of this question?
Upper
Just a minute.
upper portion of the crust belongs to the person in whose name the record
The
of right.
court is only asking one thing.
My lord.
Once you are telling that this land has been given to the petitioner,
My
the
lord.
private respondent is telling that they are having the property, they are showing the record.
But I'm answering to that. Milord.
Ah.
The minerals belongs to the
Ah.
beneath the earth, beneath the crust of the earth. That portion belongs to the petitioner because they have paid money to the corporation for excavating the minerals. And the upper portion, the crust,
that is belong to the persons who are claiming to be the owner. The record of right belongs to whom? The two parts of the land. The
Where is that?
That is the settled.
Kindly come to his record of right. Kindly come to his record of right. Page 14 of the CAN application.
My lord.
Page 14 of the CAN application. What is the area? What is the area mentioned?
It is below Khotiar number 1023/2. Then is such and such. Portion is below 0.334.
So now you come to the page 32, which is the schedule which you have given to the WBTC DSC. Page 32 of the writ petition.
My lord.
So what is the area?
Lot number 146.
Second, niche down 1552, 12522 to 1257. So there is no area. So how it can be upper and lower can be taken into consideration?
সেটা বলছে তো আগে কাউকে দিইনি মানে রিভোক হচ্ছে রিভোক যখন বলছে কাউকে দিইনি তার মানে রিভোক হয়ে গেছে বলে কাউকে হচ্ছে 18 তো বলছে যে কাউকে দিইনি কাউকে দেওয়া হয়নি
Same dag number.
Dag number area, because you are telling two part. Show me the two part. One part is given to the authority.
Beneath the earth surface, the earth surface belong to the persons who are.
So that's where is the law? Show me.
That the corporation will be able to.
May I assist your
apply
lordship?
your lordship.
Last day, on the last occasion, I have just given. Your lordship is West Bengal Estate Acquisition Act, Section 5. If your lordship kindly sees Section 5, I think I. What happens, your lordship? The upper surface belongs to the owner. The subsoil belongs to the state government. 5I. Upon the due publication of a notification under Section 4 on and from the date of the vesting, the estate and the rights of the intermediaries in the estate to which the direction applies shall vest in the state, free from encumbrances in particular and without prejudice to the generality of the provision of this clause. Every one of the following rights may be owned by an intermediary shall vest in the state, namely, right in subsoil, including the rights in mines and minerals. So you may be the owner of the upper portion of the soil, but the subsoil belongs to the state. So that's the, I think there is a confusion in the addition of party application. He can't be an added as a party. He may be a
government has one show a document.
Next second.
This particular thing has been granted to the West Bengal the Mineral Development Corporation Limited.
So after this letter, so as per I, okay, you subsoil including the rights of mines and minerals.
Yes,
Correct. In the subsoil including rights in mines and minerals, rights of hearts, bazaar, ferries, whatever it is. So where is that? It has been notified. Kindly come to the 5 again. Upon the due publication of the notification under Section 4. Where is the notification? This area is the mines and minerals.
Yes.
That's why the petitioner will be only for the subsoil of the upper area and the where the mines and minerals is located. He cannot claim that mines and minerals, and it is the state can auction and utilize that. That is Section 4.
My lord, your lordship, kindly excuse me, my lord. Answer is, my lord, yes, in my application addition of party, page 29, your lordship, kindly. Page 29. I made an application under the RTA Act with a view to know whether the land is vested to the state government or not. Now the revenue officer attached to the office of the BLLRO has said, supply information. In reply to his application, this is to inform you regarding Hatgacha such and such, plot number such and such, short, as per scan database record, above plot are not vested, recorded in the name of different riots.
No, that is not the dispute. You are the owner.
Yes.
As per the record. Now they have given to the other authority, government has given the authority with regard to the mines and minerals. In the upper, there is a earth, and if you relocate the earth, then you will find the mines. If there is a mines, then the authority has to notify it this area is mine,
yes,
and this
demarcation and all
this
these
you
things
will
that is
not
given.
utilize. This will
Yes.
be utilized by, as per my understanding.
Yes, yes,
Section 4.
yes.
So
And
where is the
there
Section 4 notification?
Not only one interruption, Millard, I did not find any lease deed indicating that it has been granted.
Correct. That's
If that be the position, my lord,
you're also not specifying in your accepts report.
That is
So whether this is the Section 4 notice, it was notified, subsequently
And
the notice
specification,
was issued and that was allotted.
and
Shall be.
specification.
It shall be.
Yes, has been closed.
Shall be. If it shall be, so which date that has been granted?
done.
Yes,
And with the liberty to the authority to lease out to the third party.
That's the point, my lord.
These are the three things.
That's the point.
my lord, one prayer. My lord, what I have understood from the petition, you are kindly to give me 2 or 3 minutes time. What I have
I
understood.
am giving full 1 hour. I don't think any advocate said that this court is not giving time.
No, that is true.
Not at all.
He's
a
practicing advocate, he cannot say that. My lord, you are kindly just bear me, my lord. Hey, Partha, just you are kindly bear me, my lord. My lord, your lordship need not go into the melody record, you just bear me, my lord. What is the scheme for mining as per the Current Act and the rule of the government? That actual owner in respect of the mining is the Department of Commerce and Industry of the Government of West Bengal. Now, he is the owner of this property. Now, he will, my lord, engage West Bengal Minor Development Corporation Limited, that he will execute the lease in their favor, and thereafter the corporation, my lord, again, my lord, issue the third person for, my lord, the sublease for. This is the scheme of the act. Now, your lordship kindly come page 29.
29.
29. Your
Correct.
lordship
I
kindly
am
come
there.
page 29.
I am there.
Yes, your lordship kindly just, well, for my satisfaction, your lordship. Well, it starts from the, my lord, the lease has been start from this page. Now this has been issued by the Joint Secretary to the Government of West Bengal, Department of Commerce and
Which
Industry.
page you are relying upon?
Page 29 of the, my lord, the writ petition. How I have been affected, your lordship.
Yes.
Yes. Now, subject, my lord, this letter has been issued to the Managing Director, West Bengal Mining Development Corporation. Subject, grant of long-term mining lease of block Hatgesia, where our, my lord, the land is there. Now, your lordship, kindly allow me to read. I am directed to refer to your application dated 29 December
2018.
2008, received on 9 January
2008, sorry.
On the subject mentioned above, I am to state that due consideration, government has been pleased to order that a mining lease for block Blackstone in respect of the other mentioned for a period of 20 years shall be, your lordship kindly marked it, shall be granted provisionally to you on your complying with following condition, execution according to within 6 months from the date of order, a lease deed duly approved by the government. My lord, this is the, my lord, starting point. Now, in pursuance of this, my lord, letter, there is, my lord, from their document, your lordship kindly come page 32, wherein, my lord, our plot are there. My lord, from this document, my lord, there is no, my lord, the document, it has been annexed that the state government has granted any lease in favor of the corporation, that is West Bengal Mining Development Corporation. This is one part. Now, your lordship kindly come page 33. Again, my lord, the Department of Corporation issued a letter dated 30th November 2018. Now, grant of mining lease in respect of Hatgesia, such and such. Now, the same, my lord, the language is there. I am directed to...
Correct, the same is there.
Same, will be. Now, your lordship kindly see.
Where no grant order.
Now, your lordship kindly see that where no grant order was issued previously to anyone, organization, and upon due consideration of the government has been pleased order that a mining lease for Blackstone in respect of area for period of 20 years shall be granted. My lord, now earlier letter was of 2010. Now this letter, my lord, then has been issued in the year of 2018. In between that, the state government has, my lord, univocally stated that in between no mining lease has been granted to anybody. Here also this word has been used by saying that shall be. So at this stage, up to 2018, the West Bengal Development Corporation has not received any mining lease. No execution, nothing of this sort. Now, interestingly, your lordship kindly come. Next page, your lordship kindly come, page 35. This is in respect of Jetia. Similar language. Previously, it has not been done. Lease will be granted to you. Now, your lordship kindly come. In between that, page 43.
Without getting the.
My lord, it is very much clear. It is very much clear that from the year of 2010 to 2018, there is no lease, nothing of this sort. Now, your lordship kindly come, page 43.
Yes.
Now, the writ petitioner is claiming that I have got the property by way of, my lord, the tender. Now, your lordship kindly see who is the date. Date is 16 April 2013. Now, your lordship kindly see the tender for exploration of mining lease, such and such, such and such. In reference to this is to info as per your online application, my lord, this is the, my lord, the tender letter. Now, next page, your lordship kindly come, page 44, middle portion. Last
Yes, yes.
date of submission.
Mr. Dasgupta, I think this is to be decided after the affidavit. Correct. And I will specific pass and direct the state authority to place all the record with regard to section 4, section
is
5.
there. It's there. Is there in the report?
Where is that?
We have filed 2 reports.
May I just indicate the?
Who are you?
And the corporation. Could you kindly takes up the report submitted by Mr. Samant on behalf of the state?
Yes.
Sir, কোনটা দেখাতে কোন report?
মোটাটা।
এটা হচ্ছে
First report. 17 July 2025.
Yes. Yes.
Yes.
Kindly come to page 26 of that report.
Please.
Yes.
Now, see, this is the lease. Copy of the registered lease deeds granted by the state of West Bengal in favor of Mineral Development Corporation.
What is the date?
It
Lordship.
is the 25th of September 2020.
If that deliberation, how before that,
21.
I have not interrupted you.
no, ঠিক আছে,
September 2020.
2020.
20, yes.
The lease deed was executed and it was registered before the competent authority. Now, Lordship, may I just indicate the procedure?
Yes.
My learned advisory, they all through pointed out the copy of the letter of grant order. Grant order says it's a allocation, provisional allocation. After this allocation, the lessee, they are required to obtain all statutory clearance, environment clearance, mining plan, and only after completion of all the obtaining statutory formalities, the state government granted the lease.
Yes.
After that grant order issued and it was extended from time to time because the grant order is a particular period. If the statutory clearances are not achieved within that period, automatically on the pair of the allottee, the validity of the grant order is extended. So it was extended from time to time. Ultimately, upon obtaining all statutory clearance, the lease executed on 25th of September 2020.
Correct.
Now, Lordship was asking for the notification. Lordship, kindly come to the second paragraph of that page. Whereas the state of West Bengal video notification number so and so dated 8 November 2002, Reserve Mouja so and so under Mohammad Bajar Police Station, District Birbhum for exploration of Blackstone by the West Bengal Mineral Development Trading Corporation. So this is the notification by virtue of which state of West Bengal published that this particular area belongs to mineral bearing area and mineral development for mining purpose, it was reserved. So everything has been complied with.
Page 58.
After that, this and the schedule of land,
Page 58.
it is start from page 28, next page.
Yes.
The area of the lease, plot number, Mouja, jail number, and thereafter description of all the
30. Last.
It starts from page 28 till 30th.
Total
area is 178.930 acre. This is with respect of Hadgacha Jetia.
Yes.
The area 178 and in respect of Hadgacha Mouja, Lordship, may I just hand over? It is not there in record. This was executed. Lordship, kindly record. I am handing over to your Lordship on 20th January 2022. This was with regard to area of 108.53. These are the total area. Now, so as on date, the issue in
What is the total area?
Total area at page 30 of the
178.930 acres.
With respect to another lease deed, here the area is 108.53. I am handing over this to your lordship. Lordship, as on date, the issue is illegal mining.
Jatiya, what is the total rate?
This area is 108.53 acre.
Yes.
Under two different lease deeds, this total.
That is also lease deed that same date.
No, it's 20th January 2022.
Yes.
As on date, the issue is whether somebody, the private respondent or anybody else, they are extracting illegally from this leasehold area. This is the issue involved only in the present writ petition. Now, even assuming that they are the owners of a particular area within this huge leasehold area, merely of records of right cannot give them right to extract Blackstone without any authority. Even there are in 2022, the government introduced a Rayati policy, whereby the persons like the private respondents client, they can apply before the authority for grant of license. Unless that license is granted, they are not authorized to extract Blackstone from their own Rayati land. That is the law of the land. So as on date, the issue is whether they are extracting Blackstone from the leasehold area or not. That is the prayer in the writ petition. So this ownership, who are the owners, that is not at all the subject matter to be decided. Lordship, kindly come to the prayers of the writ petition. What are the prayers? Kindly come to page 20. So far as the prayer B is concerned, there is already an existing order of the coordinate bench that the district authority will not insist the petitioner from that order, they are protected. Prayer A, editing the nature of mandamus to issue commanding the respondent authority to investigate regarding the wrongful and illegal extraction of Blackstone from the Hadgacha Jetia Blackstone mine and Hadgacha Blackstone mine. So that is the scope of the writ petition, only to ascertain whether the illegal mining is going or not.
No, that's why for illegal mining, some persons are claiming that it is.
They might be the owner that cannot give them right to extract minerals from the area.
That the court has to ascertain.
For that, this honorable court directed the parties to conduct an inspection. That inspection has been carried out. I believe 2 reports have been filed on behalf of the state respondent. One in respect of Hadgacha Jetia and another in respect of Hadgacha Mouja.
Yes.
Your lordship will kindly consider that whether any proof has been ascertained with regard to illegal mining activities or not. That is the scope of the writ petition.
Not a single proof. And one more thing, Miller, apart from what he said, I find, Miller, this is as an officer of the court, I am indicating to Miller, the West Bengal Minor Mineral Concession Rule 2016 came into force on 29 July 2016. And Miller, all actions which has been taken under Rule 61 and 62 of the West Bengal Minor Mineral Rule 2002, Miller, whether this can be, Miller, at all be sustained.
You are appearing for whom?
Miller, I am appearing for 14, 15.
Who are they?
The allegation has been made that they are illegal extracting
They are the
Blackstone.
owners of the land. But we are not mining.
Okay.
This point was not answered.
So you have filed the exception to the report.
Yes, Your Lordship, we have filed. We filed the exception, and on the last occasion, Your Lordship, I have indicated in the report that the state government also found that there are, Your Lordship, the traces of, Your Lordship, the illegal mining. They have requested the state superintendent of police to find out who are the miscreants and who is actually doing the illegal mining. This is, Lordship, this is entirety in Birbhum. Now the problem is that unless this is public exchequer, I am doing it for the interest of the state, certainly for the benefit of my client also. But Your Lordship, this particular natural, Your Lordship, the minerals, mineral ores, Your Lordship, is required to be protected for the benefit of this country.
Okay.
Now, two things are important because, Your Lordship, what has happened? They were insisting for the DCR. So your lordship directed them why you are insisting for the DCR. I think the DCR chapter, your lordship, once the order is confirmed, I am okay. Second thing, why your lordship this illegal mining, your lordship is saying too much thing regarding the maintainability. Your lordship, kindly take complaint growth of. Kindly take page 184. Specifically made complaints against them because they are the main person, your lordship, who are basically, your lordship, doing this illegal mining and earning in how many crores we can't say. Lordship, kindly sees page 184. And this is not my money. This is the money of your lordship, the country, the citizens of the country. Page 184.
Whether, first of all, Milord, they should prove whether a grant of mining lease has been granted by the government of West Bengal.
Lordship, kindly take page 184. Specific complaint against them. Mr. Imran, Pappu Khan, Mosiruddin Mondol, and Sopon Das. This Sopon Das has again started this illegal mining. Page 184. And I have given letter to the Superintendent of Police, Birbhum. Not once, on many occasions. Okay. Now today, the lordship, this illegal mining has to be stopped. Otherwise, your lordship, I also understand, your lordship, we can pray before the court and the court passes an order. But now,
by the state do not show that.
I am showing. Please kindly take the report.
Kindly see, Milord, the report filed by the state so that no mining is there.
Lordship, kindly take the report once, page number 7.
Which report?
The first report,
17 July.
17 July.
Yes.
Your lordship, kindly take page number 7. Paragraph 13.
First report আমার কাছে নেই না?
আছে সব আছে মোটাটা
It is further submitted that after receipt of the said inquiry report dated 30th June and in view of the indications made thereof as regard mining activities on certain plot of land as indicated in such and such, dated 16 July 2025, the Superintendent of Police Birbhum asking him to take appropriate steps to cause inquiry to ascertain the actual offended or miscreants strictly in accordance with the law. Superintendent of Police Birbhum has been further asked to keep strict vigil over the entire scheduled area to ensure that no illegal mining activities takes place. With a memo number such and such, direction has also been passed upon the block land level Blankstone Surveillance Committee Mohammed Bazar comprised BDO, BLLRO, OC to keep strict vigil over the scheduled property area to prevent any sort of illegal mining activities thereat and to take prompt legal action if so found. Now, they have given letters also to the Superintendent of Police. Kindly take page 20 and 73. There are two documents.
Page 20 of?
Page 20 of the report itself. Page 20 is the request to the Superintendent of Police. Now kindly take page 73.
Correct.
Page 73.
So now the state has already taken steps.
No, 16th of July 2025, your lordship, kindly take page 73. Yes. Superintendent of Police is required to actually ascertain and give report to the state government.
Correct.
And this is not only for this particular mine. This is also for the other mine where they have given a report.
Milord, kindly see, Milord, for a second, if I may be permitted to interrupt, Milord. Kindly see this report, paragraph 11. Just paragraph 11, last 4 lines. That will, Milord, I think, Milord, get that out of the court. Paragraph 11 at page 6, last 4 lines.
Para 11 to 13
no lease is there.
Read para 11 to 13.
Department officer no knowledge to whether the mining lease has been granted or executed by the state government. Who has filed this? Who has filed
the additional lordship, additional district and district land reforms officer?
Kindly takes up the report. Kindly takes up the report. May I place the report?
No. In paragraph 11, last line, last 2 lines, is stated that area so for which the deponent's office has been acknowledged as to whether the mining lease has been granted and executed by the state government. Lordship. Is the officer? How we can say this? So that means casually court has stated the government advocate stated the report be submitted and he submitted the report casually. without pursuing the file, without pursuing the inspection, without anything.
Milord, your lordship may kindly ascertain, Milord, indicate that as to whether mining lease was granted. Specific, Milord, answer.
That will consider subsequently. I will direct the governor to constitute a special team.
Yes.
To constitute a special team.
I'm grateful.
To inspect the area and to file the report with regard to the illegal mining. I will direct the governor to constitute a special team.
Milord, only one thing more. Milord, my learned junior Milord had just 5-6 points he has stated. I just leave it to the. I have nothing more to say.
Who has filed this?
My learned junior has prepared this note.
No, there is no signature. Put the signature. Take the responsibility.
Lordship, my only point is the
No, take the responsibility by filing this. Take the responsibility. I will deal with this. Take the responsibility by signing this.
paragraph 5 and
That I am telling, sign this.
no, I am not placing, my lord.
Not placing. You are playing with the court.
We are submitting, my lord.
What submitting? You are giving the written instruction without the signature, and tomorrow you will go to the Supreme Court and tell that the court has not considered this. You take the responsibility and sign this and give to this. I will deal with that.
I am signing, my lord.
Sign and give it to.
I am signing, my lord. This is the fact, actual fact, my lord.
Please, sir, juniors may be given some instruction. What document is to be placed before the court? If you wanted to give the written instruction, it should be signed. Some person should be take the responsibility of that.
Yes.
Yes.
Well, on the last occasion during the course of hearing, your lordship was pleased to ask me 3 questions. Put me 3 questions, my lord. First, with regard to the allotment. Second, with regard to the PCR. And third, with regard to the illegal mining. The first, my lord, my learned friend, with appearing for the corporation, perhaps has indicated to your lordship. And with regard to the DCR, my lord, I have been instructed that there are 2 public interest litigation pending before this honorable court regarding the issue of DCR. The Lord Advocate General appearing in this matter, but that point is being considered with the division. I can provide the PIL number. And the third matter with regard to illegal mining, my lord. Your lordship has perused the my report dated 17th of July. In the report, my lord, we have specifically stated, my lord, there are, though it has been written to the SP, my lord, may I place the place, my lord? Kindly have a, my lord, come to the 17th July report, page 6, my lord.
Page 6, yes.
17th July report, my lord.
Correct. Yes.
My lord. The paragraph number 12, last paragraph,
Yes.
However, confirming specifically to the said schedule area under the second category such and such, the efforts of spot and were conducted over the schedule area in due compliance of the solemn order such and such passed by the honorable court. It would appear from the inquiry report that on such and such submitted the inspection by the.
Where is the inquiry report?
My lord.
Where is the inquiry report?
I could got it. Lord.
Where is the inquiry report? You have given the reference, second line, no? You have given the reference of the inquiry report. Where is the inquiry report?
Well, all the may I
Yeah, then yes, inquiry report dated so and so.
That is below page 23 annex R4. It would appear from the inquiry report that such and such submitted by the inspection team that during the spot inspection on 30th June 25, the inspection team did not find any mining operation and activities on the said area being conducted by any person on miscreants. However, the inspection team noticed some machinery like art, excavator, etc. within the vicinity of the said area. It further appears from the said inquiry report that the inspection team further noticed.
So if that the machinery was found, why the authorities are not seized that machinery?
Those have been seized, my lord.
Seized?
Have been, my lord.
This machinery was seized. Where is that report? Machine was seized.
My lord, may I, my lord.
If you not find any activity, but you find the excavator on the things at the spot, where is the seizure? And whether any proceeding has been initiated, who has come forward for release of that seizure?
But that part I have not taken instruction. That part I have not taken instruction.
Making a statement, no activities, and all the machineries were there, and you have not seized that, and you are submitting the report before the High Court. Very good. That's why I'm telling the governor is a proper person to appoint a special team.
I have not taken instruction to that effect, my lord.
What effect? Sir, you being the court officer, you are preparing the report and filing before the court. You should know what report is to be filed and what question will be put to you by the court after going to the report. Once you are appearing for the estate, you keep in mind all these things. Then you prepare the report. You are appearing for the estate. So you should know what would be the consequence of the report.
Those have been seized. I have the instruction below whether anybody has come forward to
Please, sir, Mines and Minerals Act. If you find any of the machine, if the machine that is not a local village, mines and machinery was found, that mines and machinery, why it was found? For the showcase or the showroom?
No, perhaps not.
For
excavation.
For something else? So naturally, the public knows that the inspection will be carried out, they will flee away. But the machine they cannot take within an hour because it is not a car, not a bicycle, not a motorcycle. For taking the excavator from the one place to one place, it requires 4 hours. So if that machine was fine, what you have done? The committee, then I call this committee before this court. What the committee has done with regard to this machine?
But there is a joint inspection team.
That's why inspection team find the machinery. What has done to the machinery?
Those have been seized, my lord.
Where is the seizure memo?
Those I don't have.
And if the seizure memo is there, then it has to be taken into 106, the unclaimed, or some person has to come for release. If it has come for the release, then the proceeding is to be initiated, and then the matter has to be placed before the learned Chief Justice or Magistrate by a regular inquiry.
I've ordered to your lordship, that is the procedure.
That is the procedure.
But I can come.
I will teach the total procedure.
My lord. There is no difficulty in saying, my lord, that those machinery was there, those have been seized. What procedure we have adopted after that, my lord, I can satisfy your lordship.
When? You go through what has happened to the machinery. If you will give the exact report, I will accept. Then otherwise, I will open my mind. I will direct the governor to appoint the special team, permanent special team for that area, so that the illegal mining should be stopped. How soon you will file the report?
Subject to convention of your lordship for any report.
Record and order. The authorities have filed the 2 reports, but this court is not satisfied with the said report. In the report dated 17th July 2025, it is mentioned that inward comma, it would appear from the inquiry report dated 30 June 2025 submitted by the inspection team that during the spot inspection on 30th June 2025, inspection team did not find any mining operations and activities on the said area being conducted by any persons / miscreants, semicolon. However, the inspection team noticed some machineries like earth excavator, etc. Some machineries, inward comma, etc. within the vicinity of the said area. Said area, full stop. Full stop. This court failed to appreciate, full stop. This court has put a specific query to the learned advocate appearing for the state. If the inspection team has not found any illegal mining, and if the authorities have found that machineries were found, what action has been taken by the authority with regard to the said machinery. Whether the machinery has been seized, if the machinery has been seized, comma, any person has come for release of the said machine, comma, if the person has come for the release of said machine, whether the any proper case has been initiated before the appropriate court. Full stop. This court has not satisfied with the report filed by the authorities. Accordingly, the authorities are directed to file a separate report with regard to both the area, that is
Hatgacha, Moja Hatgacha and Moja Jetia.
Hatgacha and
Moja Jetia.
Jetia.
Moja, those are Moja.
Moja. Okay. Within a period of 2 weeks from date, 2 weeks from date, list the matter on after supplying the copy to the petitioner. Full stop. The petitioner's liberty to take exception if any. List the matter within a week thereafter. Exception if any within a week thereafter. List the matter on 5th of March 2026 under the same heading.
Well, I have got a direct this SP to file a report because there is a
Which
superintendent of police Birbhum, because they state also written a letter who are the miscreants.
yeah, it is fine from the record that the superintendent of police of the Birbhum is directed to inspect the said making inquiry and to some and to see that illegal mining cannot be illegal mining activities cannot be done in the said area. According, the superintendent of police of the said area is directed to file a separate report with regard to the said.
Mala, I have got a humble prayer mail with regard to the addition of party. Let my application be.
I will take. Let me. Don't worry. I will hear you.
Lord, your lordship is directed to file 2 separate reports. Lord. One by the state itself and one by the SP.
Lordship, kindly pardon me, my lord. Lordship, kindly pardon me.
Okay, काम करो. Lordship, उसमें tag करो.
Grateful, my lord.
Because of my lord's kind interference, this matter will now take a different shape, otherwise nothing. Nothing in the area of Birbhum.
Mines, minerals,
Yes.
all the things is to be saved. Now it has totally vanished.
This is in Bengali, they say mafia Raj.
I cannot say here.
No, that's right.
Yes, call the matter. Fix. Both are same. Yes. Affidavit in opposition filed.
Yes, my lord. But opposition reply, my lord, the pleadings are completed.
Yes.
My lord, on the last occasion, my lord, I had given a brief background, my lord, of the case before my lord. My lord, here, my lord, just for the purpose of recapitulation, a short.
But today I don't think it will be taken because 1 o'clock I have to other matters with the division.
Yes. That's what I was telling Mr. Mithro.
So I am fixing another date because part it will be. Or you will argue for 30 minutes. You will not get.
I can't finish it, my lord. In that case, my lord, keep it, my lord, on a day convenient to your lordship. Only thing is, my interim order expires on 18th. If your lordship if your lordship keeps it before that,
your lordship can you give me 1 minute? Let me talk to him.
Hmm. 5 minutes.
5 minutes.
That's why second option I have given you. We want to continue for the some time.
Very well. But I was only thinking, since I can't complete, if some other learned councils can do their matters.
Utilize them.
Yes.
Don't worry, I will record. Hard deadline.
Mr. Dr. Malad is beyond temporal things. He doesn't need things which I need. That is the problem.
Yes.
very well, your lordship may fix it on some other. Please record that your lordship has heard us. Only thing is, if your lordship
The
fix.
learned counsel for the petitioner has argued the matter. Parties have learned counsel for the parties argued the matter at length, but due to paucity of time, hearing could not be completed. Police counsel for the petitioner submitted the interim order is till 18th of February 2026. If the matter is fixed after 18, the interim order may be extended. At the learned counsel for the parties, let the matter appear 18th February.
তোমার যেদিন তোমার যা সুবিধা হয় করো জজসাহেব কি জিজ্ঞেস
हाँ 12 noon खाली है 16 February the diary is free.
কত ফেব্রুয়ারি
16th.
16
But my diary is free, but Millard, some bar council election Millard has come on my shoulders. If it could be Millard the next day instead of 16th, if it could be 17th Millard.
17th तो खाली नहीं है ना 12 बजे खाली है 17th फिर कब खाली है देखो कब when 17 तारीख खाली है 17th at 12 noon.
But 17th at 12 noon, but only thing is, Millard, my interim order is still 18.
I will see if it knows. I will add.
Well. In both the matters, but there are two matters connected.
Both matter.
I'm grateful. Millard.
This primary council matter, my lordship was pleased to hear.
Can one,
Can I just recapitulate, my lord?
What is the
But
matter?
he has completed his argument, my lord. We have already started.
Please, this is my petition.
Mr. Joydeep Kaur is making his submission, my lord. He is, my lord, engaged for another honorable court, my lord.
Recapitulate.
May it be not today, my lord, only not today, my lord. Because, my lord, Passover, it is, if my lord can take, because my lord has a division bench, if it can be Passover, my lord, he was there, my lord, just left because of the 12 noon matter, my lord.
Huh?
The 12 noon matter was fixed, my lord.
Yes, tomorrow.
Short Passover, my lord, he commenced his argument, he will finish today.
Oh.
My lord, Mr. Joydeep Kaur, my lord. My lord,
My lord, may I?
yes, on the council.
My lord, he has commenced his argument on
Yes,
the
not comments.
Yes, he's coming.
Yes, not comments.
Senior friend, I do not know what.
Yes, not comments. I would like to recapitulate. It is my matter. I know how to conduct the matter. Please.
I do not understand.
Every time he is coming and saying, no one,
something
not
else,
even the party.
I am someone.
Nothing.
Please.
You have not added as a party as of today.
Yes.
Trying to influence the course of the proceedings.
Mr. Lahiri, as per the order dated 28th of January 2026, it is recorded counsel for the petition concluded his
Yes, and Mr. Kaur is submitting, my lord.
You will get
everything.
You will get the chance
to
for
reply.
I will hear you, no problem. Let this.
Kindly allow me, Lordship. I have filed a CAT application for party adding Lordship as a respondent.
Who are you?
I am the Lordship. I made several allegations, complaints against the petitioner before the state authority, and one case has pending.
Well, this has not been served.
So, Lordship,
in our matter.
Last coordinate bench, Lordship, allowed Justice Amrita Sinha hear the matter together.
No, my lord.
It has not been.
My lord, kindly.
I don't know what.
My lord, may I give the clear picture, my lord? Item number.
Let the matter go out of the list. Counsel for the parties is not allowing this court to hear the matter. The counsel for the parties
my lord, kindly
to hear the matter. Accordingly, the case is adjourned for 4 weeks. List the matter in the month of February, in the combined monthly list of April 2026.
My lord, kindly do not do that.
Yes,
My lord, the final hearing state, my lord.
For them, my lord, for them I will be suffering. For them, my lord, I will be suffering.
You don't know how the you have to proceed the matter. How the decorum is to be maintained. Yesterday also I have given the good lesson to one of the advocate. Instead of your all persons are arguing, let it come after you go in the chamber.
Your lordship knows all of us, my lord. We are sorry.
That's why
My lord,
Yes,
my lord,
yes,
we are
call the
sorry, my lord, we are
item
sorry.
number 15.
Your lordship, we are sorry, my lord.
My lord, may kindly.
Item
My
number
lord,
15,
we are
call
sorry, we are sorry, my lord.
item number 15. Who is for the
We are
petition?
sorry, my lord. Item number 15.
My lord, kindly reconsider. My lord, they are junior members. My lord, they were trying to, my lord.
Maybe. Junior members should know the decorum of the court.
My lord, for that, my lord, our matter will be, my lord.
Sorry.
Derailed.
You are
basically.
enjoying the interim order continue.
No, my lord, my lord, the
My lord,
petition
will
be
infruct us on 26th.
February.
Maybe. Let it be. What can be done?
My lord,
If-
kindly, my lord,
My lord, kindly.
He is one time he's telling that he's senior, second time he's telling that arguing the matter
No, my
on
lord,
marriage.
I will not
Once
argue.
he is telling, then he's coming with that. So that's
my lord,
sorry.
we all
My lord,
apologize.
we all apologize, my lord.
No,
We all apologize before your lordship, my lord.
Yes,
Kindly.
call.
My lord, the entire council will be, my lord.
Now I have adjourned.
Lordship, kindly, my lord.
Sorry.
Kindly, my lord.
Yes, call the matter. 15.
Your lordship.
My lord.
Who is for the 15?
Suffering, my lord, we all
Suffering, my lord.
Who is appearing for the 15? Yes.
But I am appealing on behalf of the Union of India.
My lord, the item now, this summer interim order was still 10th, my lord, if your lordship.
My lord, it cannot be extended, my lord.
Interim order is extended till the next date of hearing.
My lord, kindly appreciate, my lord, 20th, my lord.
Interim order is extended till next date of hearing.
My lord, kindly
next,
seize, my
the
lord,
third
the
will
interim
stay-
order,
stay.
my lord, cannot be extended,
Yes,
my lord.
no
His
problem.
entire, my lord, gamut of the matter lies till 20th of February.
No
Not
problem.
after that, my lord.
No
Kindly,
problem. No problem.
my
No
lord,
problem.
Kindly, my lord, considers that, my lord.
No problem.
Please, my lord, folded hands, my lord, we are requesting your lordship, my lord.
Sorry.
My lord, a member,
Kindly
my
request,
lord.
my lord.
No, no,
Not today, my lord. My
Your
lord.
lordship. Kindly, kindly. My lord, we all be sorry. My lord, we all be
Eh,
sorry.
call the mic. I am
My lord, kindly, my lord.
I will go to the.
My lord, we all are.
I am leaving the court. You are not allowing to
Lordship
function
may
the
kindly
court.
consider in chamber.
Kindly consider.
Consider.
We are sorry, my lord. We all.
Signing the-
Whether you allow the court to function.
Absolutely. Absolutely.
Kindly considers this in chamber.
Made the Machi Bazaar. Yes, who is for the 15?
But I am for Union of India.
But this is the matter, my lord, where the petitioner to your lordship is the Chinese community in Calcutta, who has a school in Tangra, and not only it's a school, it's a place of religious function, and also, my lord, all the festivals are celebrated there. My lord, the government of West Bengal took the building for housing the CIFA staff for 2 months. We said that for 2 months it's
Yes,
okay.
what is instruction you are having?
Jawaharlal, they make 6 submission.
Who? Who is coming, sir, madam? Who is coming? Paso.
The lordship kindly, instead of Passover, your lordship kindly take it up on next week, next Monday.
Not today.
No, Monday.
Not today.
Monday.
Not today.
Lordship.
Deeply obliged.
Next.
Deeply obliged.
I am for the petitioner. These
Madam,
matters,
16, I am for the response of 6, my lord.
item number 89. How?
90.
90. Without notice, my lord, the matter is brought in.
Item number 89.
Yesterday's list, it was item number 89.
Let's go.
Yes.
This has been brought as item number 16 without any notice to us.
Yes, sir.
Give the list of yesterday's. Give the list of yesterday.
Lord, can I draw my lord's attention to?
Let me make an inquiry in this matter.
Yes. Lord, kindly have a look to my lord.
Let me.
What? Sorry.
Yes.
My lord, kindly have a look to my lord's own order dated 16th January.
Yes.
It was directed to be listed on 3rd of February at the same heading. It was wrongly appeared in that 90.
Correct.
It having been indicated or bring to the notice of my lord's officer,
No.
it has brought today.
The officer cannot do if it is wrong. It has to be corrected.
Directed by my lord, not by the officer. My lord's direction was to appear on 3rd at the same heading.
Correct.
So it was
So
appearing
if it is
in
not
this
appeared, if it is appearing in the item number 89, 89 under which under which heading? 89?
89 and 90.
It was in the heading of urgent motion 2.
Correct. Urgent motion 2. So why the same under the same heading?
Here appeared.
Earlier the same heading urgent motion.
1.
Whatever one. record an order.
Direction is there.
Judicial order. The Leonard ASGI has pointed out that this matter was as listed yesterday
92.
as item number
92, 92.
as item number 92. 92, but nobody has made any submission for upgradation of the matter, but without any notice to the respondents and without the order of the court, the matter is listed as item number 16 of the day's list. This is full stop. Learned counsel for the petitioner submit that by an order dated 16th of January 2026, this court has passed an order directing the matter to be listed on 3rd of February 2026 under the same heading, but the matter was listed at item number 89.
92.
92. Subpara. This
same
court
heading
failed
means-
to appreciate full stop. This court finds that on 16th of January 2026, the matter was listed under the same heading of urgent motion. And according the case, this court has fixed the matter under the same heading. On 5th of February, also the matter was fixed under the same heading, that is urgent motion. But this court failed to appreciate that without any mentioning and without any order of this court, the matter is listed as item number 16 in the day's list. Considering the above, this court finds that some mischief is going on in this court, and appropriate action is to be taken against the erring officials who have placed the matter at serial number 16 from the serial number 92. Let this order be placed before the Registrar General for placing the matter before the Chief Justice for taking appropriate steps against the erring officer. This is the matter under the heading adjourn motion and item.
At this stage, can I point it to one thing?
Sorry, I am totally against three things, sir. Three things. One is the corruption, second is suppression, third is the adjournment.
So, my lord, I am not.
I am against these three.
No.
First is the suppression, second is corruption, third is the adjournment.
Perhaps I am not putting that question, my lord.
Why it has come 16? I know what is going on after 430
I have
years.
not mentioned. It is true, I have not mentioned. But in fact, it was directed to be listed as
The matter, place the matter on 26th of February 2026 for report by the Registrar General.
It was directed to be listed as urgent.
Submission report by the RG.
Anyhow, my lord, it has come, my lord, I can't.
Next. Call under the heading urgent. Yes. Call the next matter.
Yes.
ভুলে যাও কেন কালকে ক্লজটা আন্ডারলাইন করো 16 17
Please, your lordship. Deputy service, my lord.
I beg to appear for the respondent. Private respondent আছে কেউ?
All have been solved.
ওইটা underline করো, tender টা
Where
pass
the
করো।
respondent authorities floated the tender, I am drawing lordship attention. Page 22 of sorry, I objected. কেটে দাও নাহলে না
My lord, Mr. Shopun Banerjee is appearing for the state in this matter, my lord.
Yes.
Mr. Shopun Banerjee is appearing for the state in this matter. He is engaged in court room number 5, my lord. I am praying for a passover, my lord.
What is the urgency?
The tender, where my
What
tender,
is the last date?
it was open and it was declared to be cancelled. I don't know whether any further steps has been,
Declared to be cancelled the total proceeding, tender
No.
process.
not the candidature, my candidature has been,
Your candidature has been cancelled. Under what ground?
nothing, only the document.
Where is the impugned order?
Yes.
Cancelling your candidature?
Page 272, my lord.
Underline করো না
272.
Summary technical bit, my lord will find.
কালকে দেখিয়েছিল
My client name is Mrs. Radha Bimala Enterprise, my lord.
Radha Bimla Enterprises, technical qualified, criteria not fulfilled. What are the criteria not
No, nothing has been, we have already mentioned. What are the criteria you want to know?
I can indicate, my lord, why it has been this.
This is only here.
Yes, my lord.
He has.
Okay, I will, if necessary, I will give you time. Let me.
He has been
You are appearing for?
I am appearing for the respondent who floated.
Floated the
tender.
tender. That is the
Therefore,
small.
I am the main respondent to answer.
Sir,
4 KK?
4, 5,
4, 5,
6.
4, 5, 6.
You are for the 5, 5, 6. Yes.
Now, my lord, he has been disqualified in technical bid. The requirement, eligibility requirement was that in respect of a particular singular work, he needs to give a completion certificate.
For how much? How many years? One.
For one particular
Work.
work, and that in respect of one particular tender.
Where is the tender condition?
He has carried out.
Where is the
He
tender?
has.
Page 22.
He has failed to, my lord, page 28. He has given those credentials, but not of a one particular work and 1 year.
Where
He
is
has given number of.
Okay, I appreciate.
but
Where is that?
therefore, that is the reason why he has been disqualified.
Where is that? Which condition?
Condition
number?
লাগানো আছে, page that 28.
It is there.
Page 28.
Eligibility criteria, my lord, will find at page 22.
I am there.
Page 28 are the eligibility criteria.
What my learned friend is submitting, my lord, your lordship will not find the same in the eligibility criteria portion.
এই তো, clause 8 টা দাও। হ্যাঁ। দিয়েছো? Clause 9 of page 19. Clause 9 of 19. That's it. Clause 9 of 19. পেয়েছো?
Clause 9 of page 19. So that is the computerized card punching. तो 19 है तो उल्टा पाल्टा चीज है 9 of 19 तो नॉइस
And moreover, this tender has already been given to the private respondent.
Where is the condition? Show me the terms and conditions.
Yes.
One
Yes.
work is to one completion certificate of the same work is to be given. Where is that?
Page 22, my lord, will find the eligibility criteria mentioned. 3 years.
8 clause
That has been given. Now they are saying that.
Eta na, page 22.
Page 22.
Kindly have a look to Milord, page 22.
Yes.
The bidder shall have to produce. Milord, did your lordship get it? Milord? Page 22, that is
Yes.
the terms and condition of the tender.
Correct.
The first one, eligibility criteria in tender. The
Correct.
prospective bidder shall have to, this certificate manufacturing, your lordship may skip, and the bidder shall have to produce the evidence of satisfactory completion of supply. These are the materials for which tender is issued during the last 3 years prior to the date of issue of the notice under the state government constituted under such and such. Now, from the writ petition, it appears that after participation and after he was declared disqualified, he has issued certain documents. Those were post-tender.
So this is the only. So where is your 3 years continuous, 3 years completion certificate?
Turn to
3 yearটা দাও যেটা
page 127.
1 yearটা, হ্যাঁ এইটা হলো, আর 1 yearটা যেটা কমপ্লিশন দেখাচ্ছে এটা
127 onwards, my lord, 1 by 1, my lord, I'm drawing lord strategy. Page 127.
Page 120.
It is for 2018, my lord, got it. Now, my lord, page 129.
Just a minute. 127 with reference to the above, your request to supply itna. This is that work order.
Yes. Now, my lord, to 133.
Yes.
133.
Now 128 the work order was issued. To
Yes. Now
the completion
the work order and the completion certificate, my lord, is also 133.
133.
Yes, my lord. 135, 133.
133.
135.
Just a minute. 133. Yes.
Now, my lord, if your lordship can turn to 140.
Particular 140.
Yes, my lord. 138 is 140.
Yes.
Now, my lord, if your lordship kindly turn to 147. Yes, my lord. Your lordship find 22.
Yes.
My lord got it.
Yes.
It has.
Then
One up to 142. Apart from that, my lord, kindly turn after filing the tender document.
no, during last 3 years. Last 3 years means
2022.
22, 23, 20, and 24, 20, 23, 24, 25. 23, 24, 25. Where is that? This when the tender was published. What is the date of tender notice?
Yes, my lord. Tender page, your lordship find that is that page.
4th December 25.
25. Yes. 2, 23, 24, 24, 25. 23, 24, 25. These are the 3 years. So you have shown the 28, 22. There are 23, 24.
He wanted to cope up by issuing a letter that those were post rejection. After he was disqualified, he intended to give it and cope up.
From
This
where my
was-
learned friend is submitting this?
I can.
Okay, okay. Let me see.
No,
Have you
yes,
submitted?
let
Where
me-
is the 22? Okay, okay. 22. That is the page number 147.
Yes.
147 is the 2022.
167 আছে
Then 23, 24, 25.
Oh, 167. Okay. Your lordship, I'll turn to page 167.
Yes. Yes.
My lord, actor supplying of all the in terms of the work order, because I'm only drawing lordship as the completion, not the work order.
Page number?
Page 167, volume 2, my lord will find it.
167. This is
Acknowledgement for completion of the supply.
has been impaneled supplier. Supplied requisite materials. Yes, 167.
Financial year 3 বলছে
Yeah, 2025. Then
201, if you like. Because I'm satisfied, lordship, they have those documents are 201, no?
হ্যাঁ 3 financial prior to tenders. এইটাই
If your lordship can turn to 202 and 205, 2022. Yes, my lord. Acha, it is a 2018. If your lordship can turn to page
202 is not this.
তার মানে 22, 23, 24 এই তিনটে ফাইনান্সিয়াল ইয়ারে দিতে হবে।
Okay, I have to rise. Come tomorrow. Counsel for the petition argued the matter at length, but due to paucity of time, the matter cannot be due to paucity of time, hearing could not be completed. Please the matter tomorrow.
Monday.
Yes.
Any action taken, my lord?
of the petitioner.
What is the matter?
Matter is that, my lord, the petitioner availed a loan. Therefore, is only the month of February, March 2023 from Indian Bank. On the basis that he is going to purchase a flat at Calcutta area at Behala. And the bank said that the searching will be done by the bank and the valuer's report will be done by the bank.
Correct.
Yes, sir. And on the basis of which the loan was proceeded with. After that, before that, on 27 February 2023, there was an agreement with the developer which I have to submit before the bank to show that the 20% I have submitted, and on the basis of which
20% what?
20% of the consideration amount I have paid to the developer, and the 80% will be paid on the basis of the loan. The loan was the advocate of the bank gave the incumbency certificate. It is in a non-incumbency, and also the developer said that the building is being constructed as per the sanction plan of the KMC. The loan was sanctioned but not disbursed because it will be disbursed to the direct to the developer. There was a type rate agreement and everything, which I have annexed to this writ petition. This writ petition was filed in the month of March 2024. What happened? All the documents which I have filed before your lordship in the writ petition, since page 36 to page 99, will show all our back-end pages. Because on 17/3/2023, they took the signatures from the petitioner on all the blank papers. Also on the basis of the equitable mortgage paper also taken, which is at page 67. Now, my lord, there was a moratorium period to pay the EMI.
Correct.
Till July.
Correct.
I paid the first installment of EMI in the month of July. August, the bank said, and also the developer, to register the deed, so that creation of the mortgage can be done. I, on good faith, on 24/8/2023, went before the register, and the deed was executed. The deed was drafted by the developer's advocate, and bank was there on basis. On 25/8/2023, here the case starts. On 25/8/2023, a phone call came to me that your flat with the entire building is going to be demolished by the
By the?
case
Okay.
Municipal Corporation.
Okay.
I went there, the entire building was demolished by 1470 square feet, came to 600 odd. And when this matter was initially taken by the coordinate bench,
So what is your prayer here?
the prayer is that there was a type-rate agreement with the bank and the developer and the borrower. Bank, when
What is the total loan amount?
total loan amount is 52 lakhs.
So it has been released in your favor.
Not in my favor, in the favor of
Correct.
the-
Whatever your amount.
No, when it was released on 23/8/2024, 24, on the next day it has been demolished.
Correct.
And the report of the surveyor, if your lordship kindly come to page 99.
What you prayed before this court?
Because this is the
What is your prayer in the writ petition?
prayer in the writ petition is that the loan which was given, the bank was well aware that the building was not within the sanction plan. And on that basis, the building was demolished.
That all the things, sir. What you are praying in the writ petition? What is your prayer in the writ petition?
My twofold
What is the prayer petition?
My twofold prayer is that because this loan was in connivance with the illegal loan, so the loan should be stopped.
Who has applied for the loan?
I have applied for that.
Then?
No, why not? If I have applied for the loan, I am going to a nationalized bank. He is giving the signal that the property is in accordance with the sanction plan. On the basis of which signatures were taken. And my lord, one more thing, when the building was demolished,
Sir, I am asking one question. What is your prayer in the writ petition? I appreciate you. I understand your facts of the matter. What is your prayer in the writ petition? What you prayed for? What relief you prayed for?
I am the relief which I have prayed for issue commending responding to initiate proceeding against the respondent for his illegal acts of disbursing loan amount to the developer knowing the structure is illegal. And furthermore, initiating criminal proceeding against the respondent bank, respondent number 1 and 2 and names and agents for cheating the petitioner and siphoning the public money in connivance with the
So who has applied for the loan?
I have applied for the loan.
Where is the loan document?
Page 36.
Page 36.
Your Lordship kindly come page 41, which is the sanction letters.
Yes.
These are the letters. And,
yes.
And all the papers.
In whose name? Your name?
Pallav Rohatgi.
Pallav Rohatgi. You are the applicant. You have applied for the loan.
I have applied for the loan.
You have applied for the loan.
I have applied for the loan.
Correct.
I went before the bank. Bank has to.
You applied for the loan with the triparty agreement that you are going to purchase the flat and he is the developer. He will develop the property so that the loan amount, whichever it has to, as per the agreement between you and the developer, this is the amount. This amount is to be transferred to the developer. Correct. This is the agreement between all of you.
If the bank finds that the property is not in accordance with the sanction plan or there is any encumbrance, the loan will not be disbursed or the loan will not be disbursed to the.
Where is that? Which condition? Where is the condition? Show me. Show me.
Is that the tripartite agreement which is at page 54 and 55?
Now show me that which you're telling that there is an agreement that there is a clause that if the bank came to know that building is not constructed in accordance with the sanction plan, the amount will not be released. Where is that? Show me.
Page 54.
Page 54. Yes.
However, the builder or the developer shall be entitled to report cancellation of the charges being paid by the borrower under the terms of the application.
Which clause? Which clause you are reading?
It is at clause 1 and 2. Now, therefore, it is thereby agreed by and between the parties.
Yes.
Indian Bank shall have the first lien charge over the same flat and give repayment of the loan with Indian Bank granting the forward. These signatures were made, only my signature is there.
Correct.
No bank signature is there.
Okay.
They are on the back end pages. And my lord, by this order of this Honorable High Court Calcutta, it was confirmed the property was demolished because there was an illegal construction. And the
show me before the demolition of when the loan was sanctioned. What is the date of the what is the date of the sanction of the loan?
Sanction was in the month of March 2020, but it was not disbursed.
17 March 2023.
Not disbursed.
Just a minute. 17 March 2023 is the date of disbursement sanction. Okay. 17 March 2023. When the total amount has been disbursed in the account of the developer.
It is on 24th August 2023.
24th of August
2023.
2023. Loan disbursed.
Loan disbursed.
Correct. And when the demolition was made? 25th August 2023 demolition. Okay. Show me the letter you have or the authorities have informed the bank the construction made by the developer is against the violation of the building plan or without the building plan. Show me the communication made either by you or by the municipal authority or by the developer to the bank that the construction made by the developer is in violation of the building plan or without the sanction. Show me that.
This is the order of the Honorable High Court Calcutta that shows that this was and the bank made the relevant searches and also bank.
It is a complaint the corporation conducted within the presence of the might have been minor deviation, but prior to demolition, they have completed corporation. It has been submitted, is taken up. Nothing. That is with regard to the demolition.
Yes.
That's see, your question is that the bank had the knowledge, the construction has been made violation of without the sanction plan. In spite of the same, the bank has released the amount. This is your allegation.
When the value of the bank, internal value, who is the authority to see that the building is being constructed in accordance with law as per the sanction plan. He is giving the report, which is at page 99. Page 99, he is giving the report that the property is 96 onwards, the report of the valuer of the bank. Page 97, clause 9. Whether the construction as per the approved plan ensures photocopy of the approved building plan.
Correct.
Yes, copy of the sanction plan. Whether any major deviation observed from the approved plan, no. On March 2023, they are saying that there is no.
Correct. Correct.
And the initiation of the proceeding here shows that prior to March, the demolition orders were passed.
When?
This order shows that prior to that, it was known to the developer and to everybody that the building was.
Where shows? Which paragraph you are reading? Where is the date mentioned in the order? Show.
The petitioner complains that the corporation conducted demolition work on the 280 Diamond Harbour 123.
Correct.
The order was of 30th August 2023.
Correct.
That means the demolition has been already done before 30th August 2023. Illegal construction has been already done.
Correct. Yes.
And prior to 30th August, the demolition was made.
Correct. No, 25th August demolition was made. Yes, and the loan was sanctioned on amount was disbursed on 24th, and loan was sanctioned on March. And this, what is the date of this legal opinion?
8 March.
8 March. So after the loan was sanctioned, you have not stated there's no building has not been this opinion given by the valuer or the lawyer of the bank is not correct.
No,
Sir,
we came
I
to
am giving one you opportunity to think of if you want to withdraw, go before the appropriate forum for the damages. This court, if you want, this court has to pass the order on merit, then future you will be in difficulty. I am giving you an opportunity. I am giving you an opportunity to think within 2 minutes whether you want to continue this writ petition. Then I will pass an order. Then it will be difficult for you in future. If you say you withdraw and you go before the appropriate court for the damages, then you can go. This court cannot decide all the disputed question of fact.
Even also the bank has filed section 19.
That is different thing.
He's at liberty to approach the DRT.
That is different thing. Here, how this court can say the sanction order when the municipal authority sanctioned when the municipal authority inspected, when the agreement, and it has already been demolished.
Yes.
Demolition has been carried out, so you are not in a position to take the possession of the building in question. Correct. So what is the remedy? What is the remedy?
I have to for the damages and
Then go before the civil court, give the notice, call the party, call the developer, take the action against the developer, and you pay the bank account loan. Otherwise, you have to face the consequence. This will not serve the purpose.
But minor only I will withdraw it. Only what I am advising before your lordship, that the valuer who is the bank value, he is saying that it is according to the sanction.
Yes.
But it is been demolished within
Correct.
3 months.
Correct. Might be, see, if I am the bank lawyer, suppose I am the bank lawyer, lawyer is not going to the spot. The advocate of the bank, the person who want to take the loan, he has to bring the land record, sanction letter, and all the connected. The lawyer will go to the revenue authority or municipal authority, only will see with regard to the your ownership, and the sanction order is there. You are telling that the sanction order is the bogus, the fraud number. Sanction order which is mentioned, that is the fraud number. Then if the sanction number is
I am not
so,
asking the advocate.
then no, not I am telling. Advocate has submitted the report.
No, not the advocate. Advocate is submitted to the property.
Correct.
I am asking the valuer who went to the property and valued the property.
You take action. So how the red court will do?
Oh, they give the independent.
You want to pass an order? Pass an order.
No, I'm reminding
The counsel for the petitioner has argued the matter at length.
Subject to it. Pardon me. Few facts within a minute. Before.
He is withdrawing.
Yes,
The London counsel for the petitioner argued the matter at length.
Yes.
And at length, full stop. London counsel for the petitioner, after arguing the matter at length, praised before this court for withdrawal of the present writ application. What is the CAN application?
That was the earlier kind for extension of the extended
Withdrawal of the writ application with the liberty to take appropriate step before the appropriate forum. In view of the submission made by the counsel for the petitioner, the WPA 7257 of 2024 is dismissed as withdrawn. However, the dismissal of this writ petition will not prevent the petitioner to take appropriate step before the appropriate forum.
Let's see, interim order, if any, may be vacated because.
Interim order, if any, stand vacated.
Obliged. Obliged.
Next.
With your lordship, obliged.
Well, 18 Malon appearing for the petitioner in this matter. Lordship, this is my affidavit of service, my lord. The bank has been served, my lord. Now, my lord, this is one of the most unfortunate case, my lord, wherein the petitioner, my lord, well, I have purchased a flat in 2012 well, on the basis of a loan, my lord, which was granted by Central Bank of India. Well, the loan was ongoing, my lord. In the meantime, what has happened, my lord? Well, I have made all the payments, and Central Bank of India has
against the police.
Not police, my lord.
Kindly pray.
Yes. My lord, this is an investigation not only in respect to the police, my lord. Also, Lordship will kindly sees. I have also, my lord, prayed as order of stay. Lordship will kindly sees, my lord. This is PS. After that, my lord, prayer C. My lord, prayer C. My lord, prayer D is there, my lord, and prayer E also there.
What is the prayer C?
May I? Lordship will take only 2 minutes of time, my lord. But this is a case, my lord, wherein a bank fraud has been, my lord, came into play. Bank fraud. What has happened, my lord?
Okay, go to the court.
No.
The court
My lord, this is a surfacey matter, my lord. Why I am saying, my lord? My lord, this is a case.
Surfacey, then this court is not
No.
a determination.
My lord, surfacey is before my lord Justice Jitapurto Mitra. My lord, this is a RDB matter. What? 2 minutes bolte the? Coordinated hold. This is a case, my lord, where I have paid my loan. There is no dispute in respect to that.
Okay.
My lord, today, my lord, Canara Bank, which is a syndicate bank, is coming and saying, my lord, there is an existence loan against your property.
Correct.
That is my case, my lord. My lord, Lordship will kindly takes, my lord. First, if a Lordship proceeds, my lord, Lordship will kindly takes the deed. My lord, page 34 is the deed. Lordship will kindly seize, my lord. it was executed by on Vijay Kumar Roy being
That's
the
correct, but what is your prayer? One A and B is against the police and
Matlab
CBI.
prayer is that
CBI.
three folds.
Then C is the subordinate of conduct a fair and proper inquiry.
Yes.
That is also the police.
Yes, madam.
Then
And
D.
not to take any coercive action, that is in respect to
Coercive
the
action of the go to the police.
page 30, paragraph 33, Lordship will kindly see.
Pending before the
Lordship will kindly see.
Paragraph
33 of my writ petition. The petitioner states that, petitioner states that there is a grave and extreme urgency in the matter enough as a valuation report of the suit property has already been submitted before the concerned recovery officer and the said property is imminently like to put up for auction. If such coercive steps are allowed to proceed, the petitioners being bona fide purchasers and having no fault on their part whatsoever would suffer irreparable loss and prejudice including loss of possession and title. It is further stated that the next date of hearing has been fixed for 9th February 2026 before the land recovery officer and unless immediate intervention is made by the Honorable Court, the very purpose of the present writ petition would be frustrated.
Where is the notice under challenge? Where is the notice?
But how no notice has been?
Page 93, my lord. There is a proceeding initiated in the DRT, my lord.
Lordship will kindly seize, my lord.
93.
My lord, there is an attachment.
এইটাই তো
Attachment orders, my lord. Page 93.
DRT.
DRT, my lord. The matter is pending. They can approve.
You are not a party.
Lordship will kindly,
What is your name? What is your name?
Lordship will kindly, সেই জন্য দিকটা দেখাতে চাইছি Lordship will তুই তাহলে কর মামলাটা এই এক প্রবলেম প্রত্যেকবার তো Lordship will kindly takes the deed itself page 34.
Sir, first you have to satisfy prima facie how this court is having determination. You are asked,
in respect to the
you ask for the police protection, go to the police court.
Not police protection.
Yes, and with regard to the
but that's the second
paragraph 33, paragraph 33, you are not disclose any notice which you are challenged by the issued by the authority which is as per the paragraph 33. Where is
Lordship
the
will
notice?
kindly seize, my lord.
Page 97, my lord.
To the court number 5.
Give me a second.
Page 97, my lord. There is an order of DRT.
Give me a second, my lord. Give me a second.
Judgment and final judgment and order.
99 Lordship will kindly comes, my lord. Lordship will kindly see the 9.
Yes,
Page 99. Yes.
Yes.
This is between Lordship will kindly see the name. Arun Kumar Pandey. 19 Subhash Ben
Arun Kumar Pandey.
I am not Arun Kumar Pandey. That is my prayer.
Correct.
Now Lordship will kindly seize the schedule. Lordship will kindly seize Mr. Arun Kumar Pandey. So and so 13 lakhs. Date penalty light in future interest so and so now Lordship will kindly seize the RC case is 123 of 2015. In that time I was running with the loan. I was paying the installments under Central Bank of India. That is my grievance.
Okay.
When Arun Kumar Pandey and others was ordered by the presiding officer, Debt Recovery Tribunal, who has issued the recovery.
Go to the recovery officer. You
Lordship will kindly seize. Lordship will kindly seize. I have paid the loan.
The prayer in the present writ application, prayer A and B of the present writ application reads as follows. Record it. Considering the same, this court did not find that not having the determination.
Lordship will kindly take page
Accordingly,
95.
the writ petition is released from the list of this court with the liberty to the parties to mention before the court having determination. Next.
May I, madam?
Grateful, man.
This is a case where I have not been made a party. My property is not mortgaged.
Go before the authority who has taken steps.
I am not under the surface proceeding.
Next. 20, 19 हो गया. Yes.
For the petitioner. Although the matter was directed to appear as a to be mentioned, but it is appearing as an urgent motion.
Yes.
The law is settled whether after retirement recovery can be made. After Rafiq Masi 2015 for SSC and after judgment of the our division bench, you cannot.
What is the post he was holding?
Assistant teacher.
Assistant teacher. Group B.
Headmaster.
Group B.
Not a group headmaster.
C.
Not C. No. It will be group B.
B. That's why. Group B. When he retired?
No, he retired from the post on 30th September 2023.
30th
Objection was raised on 31st October.
30th September 2020.
20 dated on 30th September 2023. And objection raised on 31st October 2023. Page 25 is the objection raised by the authority.
Renew and clarify the present page 10. Who is for the authority?
Well, we have served the notice. Pursuant to the pleasure of your lordship, we have served the notice.
Page should have been 8275 in lieu of
Your lordship, can
85.
page 25.
Yes. Concerned authorities are requested to review and clarify the present pay statement.
Present pay
Withdrawal
statement,
of pay
withdrawal
may
of
be
the pay
calculated
may be
and to
calculated
take further action.
for the necessary action, all of that is
Now they can correct it, but they cannot recover.
Yes, madam.
They can correct it, but they cannot.
They said the overdrawn amount.
Overdrawn cannot be recovered.
That is the purpose. What is the purpose for a calculation of the overdrawn? It will be better, my lord, your lordships keep it to be mentioned on Monday so that further notice I can serve.
See the notice?
I have already served the notice. Let it be. Four matters were directed to be to be mentioned pursuant to your lordship's leave. It was mentioned, my learned junior was also there to show your lordship categorically mentioned this matter will appear under the heading to be mentioned.
Today?
Yes. On 14th it was directed.
14th.
Anyhow, I'm giving our team.
As none appears on behalf of the respondents. As none appears on behalf of the respondents, for the interest of justice, the case is adjourned. Let the matter, when? Wednesday?
Oh, Monday.
Let the matter appear on 3rd February. No. आज कितना तारीख है? 5 6 है ना? Let the matter appear on 11th February.
11th.
Monday?
Can it be 10th?
10th February. 10th February.
Now, my lord, the three matters were directed to appear your lordships kindly. 65, 66, 67.
It is there?
Yes, yes. In the
60.
listed in-
These are same matters.
Same.
65, 66, 67.
Yes.
Along with serial number 65, 67 at top में है देखो उस दिन अर्जेंट मोशन का टॉप में है
आगे पत्रिका लिखेছে वो हमारा पास का है on 14th it was fixed
अर्जेंट मोशन में है क्या 11 तारीख 10 तारीख को टॉप में है कुछ टॉप है within 4 matters
yes
within 4
extend it 10 तारीख
it will be come under the urgent motion within 4 matters. Next. इको तो खत्म हो जाए. Next.
Lord, on a Friday, I don't want to trouble my lord with 20, Lord, 27 matters. All 27 matters are of same type from item 21 to 48.
21 to
48. So whatever my lord decides in one matter, that will cover all matters.
21 to 48.
Yes, I just give you lordships a brief idea about the matter, my lord.
One of the affidavit service one, my lord, we filed the affidavit in all the matter, report in the form of affidavit.
আমাকে দেবে দাওনি তো দেখো এখন দিচ্ছি
আজকে দিচ্ছি তো তুমি তো
আচ্ছা
filing this.
Lord, may I just tell your lordships only one thing. Lord, before you, I'll have to consider this and come back. Lord, the issue that I have flagged, it's a legal issue. Lord, there were bulk arbitration conducted under the National Highways Act. Lord, these are concerning acquisition of National Highways Act. Lord, under the National Highway, the acquisition is done under section 3, subsection G. I'll show you lordships, my lord. In my humble understanding of law, in 2015, two acts are involved: National Highway Act and, my lord, Fair Compensation Act of 2013. Fair Compensation Act Schedule 4 says National Highway Act will be applicable. So whatever is the provisions for computation of compensation under the 2013 Act, that will apply under the acquisition under any of the act under 2013 Act 4th schedule. National Highway Act is one of them. Now there were bulk arbitrations. which is not acceptable. We were saddled with some awards, paltry amount. My point is that the arbitrator doesn't have the determination or jurisdiction under the Act to give me the benefits under second and third schedule of the 2013 Act. So it will require some legal consideration by your lordships. If my lord gives us any day, a particular time for this matter, I don't want to hold a motion bench for this. Whenever my lord decides, my lord, I will consider this and come back. I believe this is the only report.
Other advocates are appearing in all matters. So in item number 22, my lord. 21 who is appearing?
21 to 30, my lord, I am appearing in Union of India.
No. Union of India doesn't have anything.
Who is the 21 who is appearing for the local state?
Yes, my lord. He is present, my lord.
You are appearing.
My lord, I am appearing on behalf of the National Highways Authority, my lord. My lord, from 21 to 49, my lord, 48, all these matters, my lord, I am appearing. But my lord, on 12th April 2024, my lord, Honorable Justice Shubhra Ghosh Lordship already expunged my name since I have no role here, my lord. Since my lord, still my lord, my learned friends, clerk, maybe my lord, served me a copy for them. They will mention this matter on such and such date, my lord. That's why I am appearing before your lordship. Since my lord,
number 3, 6, 2, 3, and 6.
my lord, I am appearing for National Highways Authority, my lord.
2, 3, and 6 has been deleted.
My lord. My lord.
2, 3, yes. National Highway, Chief General Manager, and Project Director.
My lord.
These 3.
My lord.
So they have been deleted.
My lord.
So you are no grievance
12th April 2024.
NHA.
But again, served with a copy of mentioning, my lord. That's why my lord.
But NHAI is the requiring body, acquiring body is the state.
So that's the NHA is not.
So they say that they have no role. Justice Ghosh has expunged them. I made them a party. It is at their cost they have got expunged. If any order is passed, they will suffer. It is on their prayer it is done. I have made them a party. They came that we have nothing to do. If my lord passes an order, allow me writ petition. They will have to accept that order.
Apart from the National Highways Authority, my lord, there are other authorities are also been lordship entrusted with by the National Highways Authorities Act lordship to develop the national highways under the ministry.
Whatever it is, the order is there. You have been expunged.
My lord.
So you're 20 who is appearing for the state.
21, my learned friend.
21 who is appearing for the state.
31,
My lord, I am coming one by one. Item number 21. Who is appearing for the state?
My lord, in 21, Mr. Ritesh Kumar Ganguly is appearing.
Okay. 22.
With,
22. I am. You are appearing for the state.
May I file the?
I will come. And
I am not getting. I am not receiving the copy.
For the state. Yes, 24. You are up. Union of India, you are appearing for all matters. I will record you. No, with regard to the here is the main the local authority. Land reform.
But Union of India has got nothing to do.
Correct.
My lord, 24.
So okay, so what do you want?
I have received objection in item 22 and 24 only.
No affidavit is filed.
No.
Whether
24
22. And this was filed by? In which matter you have filed, sir?
Yes, my lord, I am filed.
In which matter?
In 31.
31.
22 may I? 31, my lord. 22 to
Keep it. रखिए भी ना मत. खाली हो दो. So when all so report will serve the purpose. Only law point is there.
My lord, our name is my lord. State advocate.
Only law point is there, or the affidavit is required.
Let them.
Whether the state will file the affidavit, otherwise I fix the matter for hearing, then I will not allow the affidavit. Then any.
My lord, this is a very very
law point.
A law point, my lord. So I filed on the previous occasion, my lord. I say, my lord, on the previous occasion, my lord, that is a only law point we must stated. In a report in the form of affidavit, my lord, that is also law point. All the matters are similar for that reason.
Okay.
Lord, I have filed a petition. It is for them to come with affidavit or do not come with affidavit. Whatever I have received, I'll deal with them.
Preparing for whom?
Copy the.
State.
Copy the. So I have received 3 affidavits, 22, 28, 31. So whatever I have received, Lord, I'll deal with them. কাকে আগে দে আমার কাছে নেই
Record an order.
দেন একটা কপি দে আই ডোন্ট
And learned counsel for the petition submit that item number 21 to 48 is analogous matters and analogous matter full stop. In item number in WPA number 484 of 2024 comma 466 of 2024 and 476 of 2024
476 may I have another copy
number respondents number 4 the state authorities have filed their affidavit report by way of an affidavit. Let the same be kept with the record. In other matters, none have filed the report, neither filed the report nor filed their affidavit. In police, in we have police.
My lord, one thing by in item number 22, my lord,
Who is 11?
Special land
Correct, state, yes, police. So, considering the above, for the interest of justice, all the respondents are directed to file their affidavit in opposition if the respondents choose to file within a period of 2-3 weeks from date. Full stop. Reply after serving the copy to the learned counsel for the petitioner. Full stop. Reply if any be filed within 2 weeks thereafter. Full stop. April date then 2 baje.
তোমরা না দিতে পারলে বলে দাও দেবে না তাহলে টাইম বাঁচবে তো কপি দাও 26 আগে বলনি রেকর্ড করেনি ওখানে আমার কপি দাও একটা পরে আর পাবো না এ বলছে সার্ভিস করে সেটা এখনো পাইনি আমি
13th one day it will be one दो डेट दे दो 13th and 14th देखो 13th and 14th April at 2 p.m. as a specially fixed matter.
But 14th April would be a holiday.
14th and 15th or 13th and 16th April.
Not 16th and 17th keeps it. Not 2 days will come.
17th April. 16th and 17th note kari den. 16th and 17th April at 2 p.m. as a specially fixed matter. It is made clear that with the above mentioned, it is made clear that in the meantime the respondents failed to file the affidavit as directed above, comma the matter will be taken up for hearing without the affidavit.
Well, I'm so grateful.
Already
if it is expunged, why do you come and Lord every time she comes and all this? Ignore it.
What is the date number?
If Lord, if someone is not a party, she will ignore it. She will come and disturb the proceeding. Every don't accept it. Come and disturb the proceeding.
Okay, file the report not necessary, but I have given the chance if you file it. And उसमें बोला ना WP number and WP number 473.
All मिले
File the report with the same. Yes, call the next matter.
Lord, we have the affidavit services of all the matters. So we'll just give it to your Lordship's officer, my Lord, with marking the item number.
Service filed by the petitioner be kept with the record.
Gura, the item number gulo mark করে তোমায় দিয়ে দিচ্ছি।
You give to my officer, they will keep.
তিনটে আছে নাও আরেকটা ওই
Yeah. Next.
This is my application. My lord, on the last occasion, your lordship had directed me to serve a notice upon the learned advocate appearing on behalf of.
Yes, what is the prayer? Have you served the notice?
Yes, I have served. চিঠিটা কোথায় গেল? এইমাত্র দেখছিলাম চিঠিটা।
Yes, what is the prayer?
Yes, your lordship kindly comes. Well, this matter relates to shifting of an off shop. Well, I had of an off shop, a country spirit off shop. Well, I had been operating the said shop at that said site for a considerable period of time. it was by an order of the Honorable Supreme Court that all shops which fell within the domain of 500 meters of the national highway, that had to be shifted according to the direction of the Honorable Supreme Court.
Correct.
So I had to close down and shift my shop to a different place. Now, in the meanwhile, that order, which was passed by the Honorable Supreme Court, that was subsequently modified in 2018, and the exemptions which were granted, I fall within that exceptions. In the meanwhile, while I had shifted my shop, I had shifted to a different place, and I had been operating at that place. Now, where I had been operating, a disturbance ensured. The local people, they raised an agitation that I cannot run my shop over there. And while taking up that matter, it was found that there were two difficulties. One, there was a law and order situation. And secondly, the plot on which I had made an application for shifting, admittedly, I was operating at a plot adjacent to that plot and not that at that plot. So I was, a penalty was imposed upon me, which was compounded by payment of a composition money, and the authorities directed me to shift my shop. Now I made an application. This time when I made my application, I prayed that my shop be shifted at the earlier place where I used to operate my shop. Now the authorities inquired into my application, and they found that a Anganwadi center and a temple has come up. So they say that under the Rule 8, which provides that within 1,000 feet, these educational institutions and these temples and religious places should not be there. I fall within that restriction, and so I cannot operate over there. Malad, the point of contention which I place before this Honorable Court is that I have made my application on the basis that so far as that site is concerned,
what is the player now?
That is an existing site, so I should be allowed to operate my shop from that
representation.
Place. Yes, I have given. That
So
was considered.
What is the consideration? No.
Yes, your Lordship kindly comes to page 33 and 34. It starts from page 31, but the relevant portion your Lordship will find at page 33 from para 6, if your Lordship kindly comes. Or existing site definition টা পাবো অন্য বইটা আরেকটা বই নেই আরেকটা বই নেই Oh, this is the letter. Tonoy. Work on existing site. এটা ধর এটা হাতে ধর
Yes, so there is a temple and the ICDS center. What can be done?
Your Lordship, may I place the definition of existing site? Malad,
Sir, once the authority, what is the rule? Within 1,000 feet, there is school, temple is there. And what is the distance of the temple of the present and the subsequent?
So far as existing site is concerned, the rule says this will not at all be considered. May I place the rule? Lordship kindly takes my copy. I have only one.
Your Lordship kindly.
2007 এর Act.
Yes.
Lordship kindly sees.
Existing site means.
Existing, what existing site means. And then kindly comes, have my lord got existing site?
Yes.
And then the explanation. An existing site, has your lordship got it? An existing site shall continue to remain an existing site even if retail sale of liquor or any other intoxicants specified in Rule 2 under a license is stopped or closed from the existing site for whatever reasons for any period. Over here, the time is mentioned in that impugned order. Or even if the license is cancelled or suspended or withdrawn or surrendered, or even when the license lapses on the death of the person to whom or without others it was granted. This is the definition. This is the explanation. And so therefore, in the impugned order, they say that since it has been closed for this time period doesn't apply in view of this statutory rule.
No, yes, sir.
Now, may I, my lord, if your lordship kindly permits me, why this explanation, why this existing site came? My lord, earlier, there were various shops which used to sell ganja, bham and opium. Now, in 1985, after the coming of the NDPS Act, these business in these substances were prohibited. Now, all those ganja shops which had their existing sites and which were very close to temples and all other places of restrictions, well, they had applied before the government for allowing them to change the category of their trade and to allow them to do business in liquor. Now, this question came up as to why those sites which lay in a proximity to those places, they would be allowed to operate.
Correct.
And then this rule came in. It was in 1993 by notification 1408 that this rule came into being.
Correct.
And those sites, they were exempted from the rigors of Rule 8 by considering them to fall under existing site.
Correct.
Now, this rule which has come in 1993, from that onwards, which was upheld by the Honorable Supreme Court, and these persons were granted the licenses at those existing places, this is the rule which is operational in this field. So therefore, in view of the statutory rule, my application should be considered to be an application for operating my license at an existing site. Now, if your lordship kindly comes to the impugned order,
yes,
it says may I place, ma'am?
Correct.
The concept of existing site as laid down in Rule 3.3, so it refers to this provision, requires some explanation. So the administrative authority goes into this question. It says, the provision was obviously not conceived to include sites from where sale of liquor was stopped for a considerable time. How can that be? This is again contrary to the provision. In respect of such sites for grant of license, after a considerable time lapse, the procedure laid down under Rule 8 has to be rigorously followed. Whereas the rule says that whatever time it is stopped, it is not to be considered. Otherwise, the spirit of Rule 8 of Notification 800EX dated this shall be.
Notification?
That is that notification where Rule 8 says, if your lordship kindly takes to the it says the restrictions on grant. May I find it out for my lord? My lord, kindly take up the rule. It is only in cases of new sites. Restriction. উপরে এটা। এইটা স্যার উপরে, হ্যাঁ, এই যে rule.
Restriction of grant
Of license at new sites. It is specified where the restriction will apply.
Yes.
So the rule clearly draws a distinction between applicability of Rule 8 so far as existing site and new
when
site.
your
is
license was granted,
That was in 1965.
1965. Till which year you are continuing in the said place?
2015 and 2016 until when the judgment came.
When you have moved from the when you have moved
Yes.
from that place.
Yes. May I place that? Kindly comes to my shifting application, which is at page 23, Your Lordship.
2017.
No, my lord, page 23, Your Lordship.
Yes.
This is
2017.
my application. I have made an application. If Your Lordship kindly comes, approval of proposal for shifting of Chandni Pochai, my shop's name, from its existing site to the proposed new site in view of the judgment of the Honorable Supreme Court of India in civil appeal number this of 2016.
Correct.
So I had continued up to that. It was by order of the Honorable Supreme Court that I had to shift.
Correct.
And then when again I made
this application was made. So when
in 2016.
Correct. When you have shifted.
And I shifted thereafter when this after the approval of the shifting in 2016. This order is of 15/5/2017.
Correct.
15/5/2017.
Correct.
Yes.
So when you have shifted, when you have been allowed?
In 17.
When which date you have shifted and which place you have shifted?
Your Lordship kindly comes to that date 15/5/17.
Sir, this shifting side you requested.
No, Your Lordship, this is the order.
Approval has been given.
Yes. On 15/5 approval was given. I shifted next month, very next month. Your Lordship kindly sees the address. This is the existing site address and the new site, which is given just at the column just besides it.
Correct. So
Now,
17 you have shifted.
Yes.
Then
yes.
what has happened?
17. I continued operation at my shifted site
Till
21.
2021.
Your Lordship kindly comes to this order.
Therefore, directed to 35,000 you have been for challan.
Yes, yes.
Admitted irregularities to be true, the promise and take.
Kindly sees the order, Your Lordship, 27/10/2021.
Correct. So you have been given,
Yes.
you have paid challan.
Yes, yes.
So there are, what has happened?
And
after
then I made another application, which Your Lordship kindly comes to page 25 for once.
Then this is of 2021 to October.
Yes, and then
January you have made an application
Yes.
for shifting.
Yes, I made an application and they make an order
Whereas
stating, yes.
Shifting of channels was measured with the vicinity of Hindu temple and was not suitable. Shifting the temple under Itnai. I am directed to ask the further furnish the detail. Yes. So there is a temple and there is
Yes, and they say, and then the next order of the ADM, Your Lordship kindly comes. Page 26 is the final order where they say that I have to shift.
Remain suspended.
Yes.
Shall be closed imperative till the compliance of the order dated 27 January 2020.
Yes.
Okay. So
And then I made an appeal. I preferred a statutory appeal before the commissioner and thereafter an appeal before the principal secretary.
So appeal upheld.
Yes.
The order of the
additional district magistrate that was upheld by the commissioner firstly,
Correct.
and thereafter by the principal secretary, and now I have come before this order.
Now your only contention there, your existing was there, and as per the rule 3,
according to rule
section 3 II
Yes.
and rule 8, your existing means that is existing.
So the regards of rule 8 will not apply since it is an existing site.
Correct. That is your contention. Yes, sir.
First of all, my lord, I attended apology was nice. But the question is, my lord, it will, my lord, once Supreme Court says that this is no more a fact, whether, my lord, this particular thing was not considered in the definition of existing site. Existing site means suspended, something which has happened pursuant to the orders under this Bengal Excise Act. But pursuant to something new, which was laid down, the law was laid down. Well, whether it ceases to be an existing license, but that is what I have to argue.
Yes, argue.
But next Friday, can you come back?
That is the problem.
No, then
If you
no, one
persons are
more-
not ready, you could have been come up. First, he has argued the matter. The second time he is arguing the matter.
Can you come back Monday, 3 p.m.?
This court has other matters.
I tender unconditional apology.
Learned counsel for the petition has concluded his argument. Learned counsel for the state press for time. According case is adjourned. Let the matter appear on 5th of February under the same heading. Next.
Your Lordship.
6th, 5th.
Your Lordship.
Today. No, we are on 6th. Na? 12th February.
12th February.
Great. Next.
Being led by Mr. Chakraborty in this matter, Lordship.
Huh?
Lordship. Lordship, Lordship.
Opposition filed.
No, Lordship. There was a direction upon the bank to file their opposition with the order dated 27 November 2024.
Correct.
And since then, they have not served us with the copy, Lordship. The affidavit in opposition.
What is the grievance? What is the case?
Lordship, here the petitioner's application to get appointment in the compassionate ground was rejected by the bank, and the petitioner went on making multiple applications.
Which bank?
Artsville United Bank, thereafter Punjab National Bank.
Yes.
Monday, my lord. Opposition is ready, ma'am.
So when she will file, I reply. Give the advance copy. Counsel for the respondents press for time to file affidavit in opposition. Let affidavit in opposition filed within a week from date after serving the copy to the learned counsel for the petitioner. The petitioner is liberty to file reply within a week thereafter.
Lordship.
List the matter. 1 week. List the matter on 27th February.
Grateful, your Lordship.
Under the same heading.
Lordship.
Next. None appears on behalf of either of the parties. No accommodation is sought for. Let the matter appear in the combined monthly list of April 2026. Next. Yes.
To passport, your Lordship.
Who is for the petitioner? You are appearing.
Lordship, for the respondent.
Same order. None appears on behalf of the petitioner. So and so appearing for the respondent. No accommodation sought for April 2026. Yes, sir. Original site.
Lord, may I be permitted to mention a matter, my lord, for inclusion? May I be permitted to mention a matter for inclusion, my lord?
Which matter?
My
Appellate
lord,
side?
if I may pass the
Appellate side
appellate side.
or original side?
My lord,
Appellate side, no.
WPO original side, my lord.
Original side.
Original
Please
side, my
wait.
lord. My lord, I'm Krishna. Is passing the mention slip, my lord. I have
What?
instructions.
What is the urgency? क्या है? WPO.
Instructions to withdraw this matter, my lord. It's just
है,
for
list में है.
inclusion.
It is not in the list.
It's not in the list, my lord.
Mention to be mentioned for withdrawal. Come on Monday, Tuesday.
My lord, maybe for me to mention, you will recall, yesterday I have mentioned the matter, my lord, item number 82 of today's list. Now, my lord, this was the order that was passed by your lordship, where the matter was dismissed for default. Now, my lord, the honorable bench with the, my lord, the determination, item 39. My lord, this is item 39, my lord. Thereafter,
Today?
Item 39, today's list. Now, my lord, thereafter the honorable bench with the appropriate determination, my lord, had released this matter because the order was passed by your lordship. So, my lord, therefore, I have mentioned before your lordship and the matter was included.
Matter included.
Yes, yes, item number 39.
So what do you want now?
My lord, for early hearing, your lordship, of this application.
Come at 3:30 today, I will take.
My lord,
Come at 3:30 today, I will
I'll
take.
be so grateful, my lord.
Lordship. Lordship, may I be permitted to mention a matter? This is WPO, new motion. WPO 61 of 2026. I am a 63-year-old senior citizen. Previously, this matter was appearing in your, not this matter, previously, I have been filing this with the same petitioner, this matter, and your lordship has directed to appear before the learned senior citizens tribunal by the order dated 3rd December. So we have been approaching the senior citizens tribunal, but so many days have passed, no actions have been taken.
You are the senior citizen?
Yes, 63-year-old.
So what has happened?
I have been
You filed WPO?
Yes.
So when you file the application before the the authority,
15th of December.
So they have not taken up for hearing.
They have taken the application. But still now, nothing. They are telling that we have already sent for inspection, but till date, no inspection has been done.
So what you are praying for?
I'm just praying for an expeditious hearing.
So रख दो कर दो.
Obliged.
Yes, call the list.
Lordship, Lordship, that matter it was left for the last bit of hearing. It was at the stage of arguments. Your Lordship had wanted to list it on the 18th of February last month, but then wanted me to wait it out. But Lordship, it has not yet.
अरे इसका ना
25th March. Grateful.
Yes.
Lord,
appearing only for the purpose of filing the
my lord, may I say this, my lord?
by my land.
Your lordship recalls, my lord, I am being led by Mr. Bosman.
What?
I was being led by Mr.
My lord, I am here, my lord.
Your lordship.
I am here, my lord. My lord, on the last occasion when the matter was fixed, my lord, unfortunately, I could not be present. So what your lordship did was, your lordship said, file your notes. There was only one part of Mr. Sen's submission on behalf of the plaintiff, on this general point, which I wanted to deal with. So, my lord, can I just 10 minutes on any day? Just 10 minutes, but by the clock, 10 minutes. 3:45, at 4 o'clock, at 4:15, just give me 10 minutes.
That partition suit. Partition suit.
Yes, partitions.
Your lordship has heard.
Yes.
On behalf
So
of the plaintiff.
you file the return notes, Mr. Bose.
It will, if I file it, the note, but just give me 10 minutes, I'll explain to your lordship, my lord, how I wish to deal with Mr. said submission so far as this, my lord, nucleus established and the point of limitation taken by them. Just give me any date,
So the matter is listed
4:15,
as
your lordship gives me.
under the heading to be
4:15.
mentioned, filing written notes of argument by the defendant, but the learned counsel for the defendant submit that he intends to argue the matter for 10 minutes and prays for time. Let the matter appear on 25th of February at 4 p.m.
Great.
Wait,
The defendant is also directed to file the written notes.
We'll bring the notes of argument. Grateful, man.
Yes, great, deeply obliged.
Your
May
Lordship,
please, my
I
lordship.
filed GA3, Mr. Medora's permission, and the GA3 is Millard for impediment. My property, I am a company, I've got nothing to do with these people. My property has been included in Schedule A. The limited extent of my prayer, Millard, is that I wish to intervene in this suit.
So he wanted to take care of it. Why you are worrying about that?
Yes.
The plaintiff is want to take care of your property. So why you are
That is
worrying
the
about?
issue. I have no idea who this person is. And I'm a company, Millard. That's the only thing. And I've provided documents which show that if Mr. Medora today wishes to, I do not know whether Mr. Medora will want to oppose my application.
Of course I will.
GA3.
GA3.
Yes.
I want to oppose his application. His application is not maintainable according to me. There's no scope for interim relief. Kindly, my lord.
Asking for an
I know.
Petition be added as an intervener.
In a partition suit, how can a company be added
Millard,
as a party?
our
I do not
company-
know.
That I'll cite judgments. Millard.
Preposterous.
If a company's property can be added in a partition suit and that is not preposterous, then a company can be added and it will not be preposterous. My property has been added. My lord will kindly look at the plaint. My lord will kindly look at the plaint. I have annexed the plaint.
Will you file the affidavit in this?
Yes, I have to.
You will file. And what about the hearing?
That my learned friend will have to proceed with
Yes,
his
my lord, I
application.
appear for the defendant, only defendant. My lord, there is an application which I have filed for rejection of plaint, that is GA2.
What is the GA1 interim?
GA1 is my interlocutory
Yes.
application, my lord.
GA2.
Yes,
GA2
that is
his
my
application.
application.
Yes.
Yes. Well, I can start GA2, my lord.
Yes.
Yes, lordship takes the application because it's for rejection of plaint. My lord, twofold challenges to this to the plaint filed in the present suit. First, my lord, is that suit has been filed for partition of an immovable property which is situated outside the jurisdiction of this honorable court. Since the property is situated outside, admittedly, that is the plaint case. Hence, my lord, suit for partition, which is essentially a suit for land, because the land is situated outside.
So you are applying for the defendant number?
Yes, only sole defendant.
Sole defendant, yes.
Sole defendant.
First is the property is out of the jurisdiction of this court.
Yes.
Yes.
Because he claims for partition, it's a suit for land. If it's a suit for land, my lord, the plaintiff had to go to the court within whose territorial jurisdiction the land is situated. Land or the immovable property, as per the plaint case, is situated outside the jurisdiction of this honorable court.
Okay.
Hence, my lord, so far as the relief of partition of the immovable property, my lord, suit cannot lie in this honorable court.
Okay.
Second, my lord, he claims partition of the shares held by his deceased father. Suit filed for partition of shares is not maintainable. Even, my lord, if it is his if this is his plaint case, that, my lord, he has, my lord, inherited or he is entitled to the shareholding of his deceased father, But then at best he will be a shareholder in those companies. Shareholder will not have any rights so far as the assets held by these companies are concerned. Because a right of a shareholder, Lordship is aware, is only to receive dividends and has some voices in managing and administering the companies. Dividends only he is entitled to if the company declares dividend.
Yes.
Barring that, Malad, a shareholder cannot have any right, number one, to sue for partition of shares, and number two, shareholder will not have any rights of the assets held by the companies wherein allegedly he is a shareholder.
Yes.
Yes. Now, Malad, to show that the pleadings in the plaint, that it is especially the plaint case that the immovable property is situated outside the jurisdiction of this honorable court, Lordship will kindly see, Malad, page 26 of GA2, page 26 of GA2, which is internal page 11 of the plaint.
Yes.
Malad, kindly see internal page, Malad, 11 running page 26, paragraph 13. But this is his averment. The plaintiff states that apart from the aforesaid stakes in the companies as stated above, the plaintiff's father inherited right, title and interest in respect of his ancestral property situated at 2 by 1 Bright Street Police Station, Koraya, Kolkata 19 from his father, late Bishwanath Jhunjhunwala, which is situated outside the jurisdiction of this honorable court.
Yes.
Now, Lord, he has claimed for partition of this immovable property that your lordship will find from the prayers made in the plaint, my lord, running page 32 of my application. Preliminary decree for partition declaring respective shares of the plaintiff and the defendant in respect of the assets of late Sunil Jhunjhunwala as described in Schedule A and B hereunder.
Yes.
Now, Schedule A and B, lordship, is at page 34 of the application. Kindly see Schedule A. This is the Bright Street property, which is outside the jurisdiction of this honorable court.
Correct. Yes.
Now, Mulad, the second submission is that he cannot sue for partition of shares.
Yes.
Mulad, kindly comes to Mulad again. Mulad, running page 26 of my application, which is paragraph 13 of his plate.
Yes.
Yes. Mulad, kindly see from the middle of paragraph 13. Apart from the same, the plaintiff's father maintained bank accounts, fixed deposits, demat accounts, valuables and bank lockers, details which are presently are not within the knowledge of the plaintiff. He craves leave to amend the plaint. Now, Mulad, kindly comes to very important paragraph, page 28, paragraph 17.
Yes.
The plaintiff states that since for a considerable
Yes.
period of time, his father resided with the defendant and also with the children of the defendant from a previous marriage. Hence, there is every possibility that they will deprive the plaintiff from his lawful and legitimate share and or entitlement of the assets and properties which he has inherited from his father, Sunil Jhunjhunwala, alias Sunil Jhunjhunwala. Not the assets and properties that whose partition has been sought for, those assets have been described in Schedule A at page 34. Schedule B, sorry, at page 34.
Yes.
Yes, kindly see, Malad. Schedule B is, Malad, what he claims is half shares in the following companies.
Yes.
And kindly see, Malad, if he, at best, he has inherited the rights of his father as a son, then, Malad, at best, he will be a shareholder. And he has claimed partition of the shares held by these companies.
By shareholder, where he stated that You want the share?
My lord, kindly see Schedule B.
Yes. Acha share, half
Uh,
share.
Half
That
shares
share,
in the following companies.
that share is with regard to the portion, not share with regard to the company share. I think
But
so.
But if Lordship sees his pleadings in the plaint, kindly see, my lord, page 28, paragraph 17 and 18.
Correct.
His claim, and Lordship will kindly see, my lord, page 29, paragraph 20 of his plaint.
Half portion.
Plaintiff is legally entitled to a decree for partition of the assets and other estates of
Correct.
Sunil Jhunjhunwala
Correct.
as mentioned in Schedule A
Correct.
and B hereunder. In any event, half portion of the estate of Sunil Jhunjhunwala,
Correct.
which he is legally entitled to enjoy as per the provisions of the prevailing succession laws of the country.
Correct.
He is claiming, my lord, according to the plaintiff, the estate is the immovable property at Bright Street number 1 and the shares in the companies. He wants a partition in the companies. That means he is exercising his rights allegedly as a shareholder in immovable properties if held by the companies. Shareholder, my lord, cannot have any right so far as the immovable properties of the companies are concerned.
Okay.
Schedule B, he starts saying that half shares in the following companies. Now, not admittedly going by the schedule at page 34, the plaintiff is not a shareholder.
Yes.
But kindly see, I'll take your lordship through the list. Kindly see the first company, serial number 1 is Delta International Limited. He only says that his father is a shareholder. He is not a shareholder. And nowhere, Mulad, he has given the entire list, Mulad, which runs up to page.
So where will the share of the father will go after the death of the father?
No, he has to apply for transmission of shares. There is an appropriate remedy provided to him under the Companies Act.
Unless and now, that's why the unless and until the court is not declare his entitlement, how the company court can decide the title?
No, now, Mulad, NCLT under the Companies Act.
NCLT. That's why the legal question is that father died, admittedly having the company, having the share. As per your case, yes, this court cannot partition the shares.
Yes.
Cannot ask the shares. But this court can declare the entitlement. Then once the share entitlement of the plaintiff is declared that is entitled, then only he can go to the company company and he make an application as he's having the share is to be divided.
First of all,
Whether the company could decide the title, the title.
Now, NCLT has been conferred wide powers under the 2013 Act.
Show me where under the Companies Act whether the 430 whether this.
No, not under Section 430. Now, Malad, Satori Global, Malad, the Sailaja Krishna judgment, but I'll just.
Show.
I can just. I'll just give Malad. My learned advocate on record, Mr. Upadhyay, is there in court. If he can show your lordship the soft copy of the judgment, I'm not carrying a printout. The Satori Global judgment, the Supreme Court has now said that even disputed questions of fact can also be decided by the NCLT.
That's correct. But the title can be declared by the company NCLT.
The issue was challenged. Issue before in Satori Global was regarding the validity of the gift deed. But the Supreme Court has said that these issues can be decided by the NCLT because now under the Companies Act, NCLT has been given wide powers.
Show
Show me
the judgment.
Kindly give me 1 minute, Mulad. 1 minute. Kindly gives me 1 minute. My lordship, I can tell your lordship the citation. Well, it's a 2025 SCC online SC 1889.
Page.
Well, this is 2025 SCC online SC 1889.
1889. Yes.
Yes, Mulad, I'll just read out the relevant portions of the judgment, Mulad. I'll thereafter, Mulad, within a few minutes, I'll send a copy across. Mulad, the issue was, Mulad, whether, Mulad, oh yes, Mulad, the question was, did the NCLT have jurisdiction to decide whether a gift deed is valid or not? But that was the question before the Supreme Court. Now, Mulad, I'll just read out the paragraph. This issue pertains to the central question in the current case. The gift deed has been challenged on various grounds, but before we proceed to decide on the merits, we would first decide whether NCLT possesses jurisdiction to decide this issue itself. Now, Mulad, in Radharaman versus Chandrasekhar Raja, this court held CLB would be denuded of the power to provide the diverse reliefs present in the 56 Act if the court does not give effect to the wide jurisdiction conferred on the CLB in matters concerning Section 397 and 390 thereof. The instruction passage, Malad, which has been quoted is Section 397 and 398 of the Act empowers the Company Law Board to remove oppression and mismanagement. If consequence of refusal to exercise jurisdiction would lead to a total chaos or mismanagement of the company, would still the Company Law Board be powerless to pass appropriate orders is the question. Now it has been held, but the jurisdiction of the Company Law Board has been couched in wide terms and as diverse reliefs can be granted by it to keep the company functioning. Is it not desirable to pass an order which for all intent and purport would be beneficial to the company itself and the majority of the members? A court of law can hardly satisfy all the litigants before it. This, however, by itself would not mean that the Company Law Board would refuse to exercise its jurisdiction, although the statute confers such a power on it. Now, it has been held that it is now a well settled principle of law that the courts should lean in favor of such construction of the statute whereby its jurisdiction is retained, enabling it to mold the relief, subject of course to the applicability of the law in the fact situation obtaining in the each case. Now, here it has been also held. I'll just read out the most relevant paragraph, paragraph 30 and 31. The aforesaid decision confirms the view that NCLT CLB possesses a wide jurisdiction to decide all such matters that are incident and or integral to the complaint alleging oppression and mismanagement. Such power is, however, subjected to any legislative enactment, specially debarring the NCLT CLB from exercising its powers in this respect. In this case, it is an admitted fact that the determination of whether the gift deed is valid or not is central to the decision herein, and therefore the NCLT did have the jurisdiction to decide whether the gift deed is valid or not, or whether it is against the provisions of the 1956 Act or the internal regulations of the company, including but not limited to the AOA and the Memorandum of Association. Now, the issue was whether the gift deed was valid or not. my lord, validity of a gift deed, my lord, always attracts a challenge or a decision with respect to a title. My lord, if NCLT or the CLB under the Companies Act 2013 has been given such wide powers to decide such issue, including the validity of a document in terms whereof, my lord, title is transferred, then, my lord, in my humble submission, the issue whether my learned friend is at all a shareholder in these companies ought to be decided by the NCLT and not a civil court. Because today, my lord, if lordship sees the plain case, my lord, he has prayed for decree for partition in respect of an immovable property which is outside the jurisdiction, and he has claimed decree of partition of all the companies. But companies cannot be partitioned. If he is a shareholder, first, my lord, he has to demonstrate that he is a shareholder. And if he is asking for partition of shares, that's not possible. Then, my lord, in my humble submission, the plain does not disclose any cause of action. My lord, because lordship knows, my lord, if he is not a shareholder, then, my lord, he is an outsider. Then, my lord, my lord, in my humble submission cannot question, my lord, the rights internal management or the rules governing the internal management of the company. That's, my lord, protected by the doctrine of indoor management. My lord, what he can do is that for being a shareholder, he can complain regarding operation and mismanagement. So once he is a shareholder, his rights are only to receive dividends and participate in the profits, provided dividends are declared by the company. Not kindly see in this respect, not the single bench decision of this honorable court. I'll just, but this is 2011 volume 3 CHN, page 147. We have a copy.
Volume?
2011 volume 3 CHN 147.
Yes.
My learned friend is there in court, but he'll hand over a copy to your lordship, Bernard. This is the Burlia single bench judgment of this honorable court.
Extra copy. Thank you.
Yes.
Yes. Lordship will kindly come to paragraph 12. But kindly see paragraph 12. In the present case, the primary relief of partition of the assets of the several companies cannot be para 12. But this is a 2011 3 CHN 147.
What is the name of the part?
Narendra Kumar Barlia versus Om Prakash Barlia.
No.
This is some other Burlia judgment.
Pesticides were.
No, that's the division bench judgment, my lord.
No, it is another. Pesticides and Brewers Limited.
Breweries. Quite an interesting combination. On the one hand, pesticide, and on the other hand, a brewery. They'll kill you either way.
Who are the judges?
No, this is a single bench judgment of Justice Shonjit Banerjee. Yes. Lordship, this is a single bench judgment of 2011. Lordship will straight away come to Malad, paragraph 11. Paragraph 12.
Yes.
Yes, one kindly see. In the present case, the primary relief of partition of the assets of the several companies cannot be a claim falling within the exception to the rule of Foss versus Harbottle. A personal cause of action of the plaintiffs has been carried by way of a confused derivative action covering strangely a number of companies without the first plaintiff establishing or attempting to establish that he is a shareholder of each of the companies that he professes to sue on behalf of. Add to that the fact that two other plaintiffs are not parties to the derivative action and sue for their personal benefit, that makes the plaint a strange animal. It is like the plaintiffs attempting to sail in two boats that are globes apart. There is no application on the date for rejection of the plaint relating to the suit, but since it appears prima facie that the suit is unlikely to succeed, the interlocutory reliefs claimed by the plaintiffs cannot be acceded to. GA number such and such is dismissed with costs assessed at 1000 GMs to be paid by the defendant. All interim orders stand vacated with immediate effect. My lord, the reason why, my lord, it has been observed that the suit is unlikely to succeed is because the personal cause of action has been carried on, which is in fact a confused derivative action without, my lord, the plaintiff establishing that the plaintiff is a shareholder in these companies. Going by, my lord, the plaint case itself, my lord, the plaintiff has not established his shareholding in the companies whose particulars have been provided at page 34. Now, my lord, kindly see the Delhi High Court, Delhi High Court judgment. This is, my lord.
That's why he has filed this suit before this court for declaring.
No, my lord, if lordship sees his reliefs, his relief is for partition.
Correct.
Page 32 of my application is his prayer A. Preliminary decree for partition, declaring respective shares of the plaintiff and the defendant in respect of the assets in Schedule A and Schedule B.
Correct.
My lord,
Then you come to the final decree.
Final decree.
For the preliminary decree, he is to be declared whether he is entitled or not. So now come to the judgment of the which you are referred to.
Yes.
Referred to the primary relief for partition in assets of several companies cannot be claimed falling within the exception to the rule of the first one. So the personal cause of action a plaintiff has been carried by way of a confused derivative action covering strangely number companies. So he has stated in this case he has stated the company was stating that the preliminary decree be passed for partition. Then once the preliminary decree be passed, then it will come to the final decree.
Yes, lordship is correct.
What is the preliminary form? Preliminary form is that first he
Declaration
has
of
to declare
shares.
yes, he is entitled to half share, 1/4 share, 1/3 share, whatever it is.
Yes.
Once the share is preliminary form, it is declared, then you come to and you will not thereafter you will not come forward for partition. Then the final decree is to be drawn by appointment of the commissioner or whatever it is. That is the law of the partition.
Yes, but lordships kindly sees one thing. My lord, admittedly, if my lord, even if I, my lord, proceed in this manner, that he has prayed for declaration of shares. Then, my lord,
That is different thing. If you are saying that your share can not be declared by the civil suit, it can be declared by the NCLT or CLB. That is different. That court will. But with regard to the prayer portion in the suit, that is the prayer. We will go for the partition suit. First, we have asking for the plenary decree, declaring our title, then the final decree. So
yes.
Correct.
Yes.
Now, as your submission that yes, he is claiming claiming the partition in the company, and the company cannot be partition the shares, and that can be done by the company, NCLT or CLB, whatever
Yes.
it is.
Suit for because essentially.
Correct. So suit for partition does not like this. This is
Yes, suit for because declaration of shares cannot be granted by a court if the plaintiff otherwise is not a shareholder.
Okay, that I understood. Okay. Next.
Yes, next, my lord.
May I take your lordship's leave? Today there's a 3:30, so I have something else which has been advanced. Grateful. My interim order will be expiring today. My learned friend will. Grateful.
Yes. Next, my lord.
You will file affidavit.
File an affidavit.
GA3, I'll file my affidavit in 3 weeks, my lord.
3 weeks.
3 weeks. That
2
is
weeks.
exactly why I asked Mr. Medora.
No. 2 weeks, my lord, because client is in Delhi. That is why.
I'll file within a week.
Yes.
Yes. My lord, he is asking for a declaration in respect of the assets in Schedule A and Schedule B. That's his preliminary decree. Because in preliminary decree, the shares have to be declared.
Correct.
Only once the shares are declared, then, my lord, the suit can proceed for passing of a final decree.
Correct.
But going by the plain case itself, my lord, he is not a shareholder in any of these companies.
Correct. You have raised the two contention with regard to the Schedule A property outside the jurisdiction of the court. There are suit of land. So this court
Yes.
cannot.
This
And
court
second is
cannot.
with regard to he is not having the share and the share cannot be decided.
Yes, but there cannot be a suit filed for partition of shares.
Yes. That is
And
the-
number two, my lord, if lordship sees his pleadings, my lord, kindly comes to again few of his paragraphs, my lord, page 28, paragraph 17 and 18.
Yes.
Paragraph 17, 18, and my lord, paragraph 20 at page 29. Because
Yes.
yes, especially page 29, para 20, because from the middle of para 20 at page 29, he has asserted, it is his pleading, in any event, the plaintiff has inherited half portion of the estate of Sunil Jhunjhunwala. He is legally entitled to enjoy as per the provisions of the prevailing succession laws of the country.
Yes.
According to the plaintiff, the estate is the immovable property and the shares. Going by the plain case, estate of his deceased father is the immovable property and the shares. So when he is asking for a partition of the estate, that signifies that he is asking for partition of shares. Now, suit filed for partition of shares is not maintainable. But kindly see the next judgment of the Delhi High Court. This is, my lord, Mr. Upadhyay. This is 2014 SCC Online, Delhi 1324.
Page.
This is 2014 SCC Online, Delhi 1324.
Yes.
Yes. Lordship will first come to paragraph 7 of this judgment.
Yes.
Yes. Where issue of shareholding in a company is the bone of contention, the pleadings have to be specific with reference to what percentage of the shareholding is claimed by the plaintiff for the reason a company is distinct from its shareholders. The assets of a company belong to the company and are not the assets of the shareholder. Through the shares, exercising control over the company, the shareholders may manage the assets of the company, but no shareholder can sue for partition of the assets of the company as can be done by a partner or joint or co-owners of a property. The plaint is a hodgepodge of pleadings intermixing the issue of shareholdings in companies and properties held in the individual names of the parties. But this is the same in this case, because he also, my lord, has made a
Yes.
yes. Now kindly see, as observed by the Supreme Court in Bachagazdar, a company being a juristic person is the owner of the assets in its name, and a shareholder has no right over the assets of the company. He is only entitled to the dividends when declared by the company from time to time. A shareholder cannot ask a company for partition on the basis of his shareholding. Now, Malad kindly turns few pages and kindly comes to Malad paragraph 23. This is Malad very important, Malad paragraph 23. Malad kindly see, the plaint in the instant case is a classic instance of mufassal pleadings in a corporate litigation. A claim for change of shareholding in companies has been intermingled with a claim for partition of immovable properties held by some of the companies and in the name of some individuals. The plaint overlooks the fact that a company is a distinct juristic entity vis-a-vis its shareholders and movable as also immovable properties in the name of the company belong to the company. Now, my lord, a shareholder cannot seek partition pleading that since he holds 20% shares of a company, he is entitled to a partition of the movable and immovable properties of the it should be company and to be put in possession of 20% thereof. Shareholder cannot, my lord, ask for partition in respect of movables and immovables held by the companies. So, my lord, partition preliminary decree for partition in respect of Schedule B, which comprises of shareholdings of these companies, is not maintainable.
Yes. Yes.
But this is the Delhi High Court view. Now, my lord, kindly see the Madras High Court view. This is a Manupatra printout of my lord K.S. Motilal. But this is the Madras High Court judgment, my lord, of 2001, K.S. Motilal. My lordship will kindly come to, my lord, paragraph 45. Paragraph 45, your lordship will find at PDF page 11 of the judgment. The page numbers are at the bottom, page 11. Now, lordship will kindly turn the page. Paragraph 45 spills over to page 12.
Yes.
Yes. But kindly see what were the issues. Just from the middle of the page, in these three company petitions, the following points arise for consideration. But thereafter, my lordship will come to serial number 9 and 10 towards the bottom of the page. What are the rights of the shareholders like the petitioner and the contested respondents in the first respondent company? Then, my lord, whether the shareholder could claim any specific share or interest in the property held or owned by the company or seek for partition of the company's assets. But this was the question before the Madras High Court, and kindly see how it has been answered. Lordship will kindly comes to paragraph, my lord, 47. Point numbers 9 and 10 has been decided. But kindly see what the Madras High Court holds. Also, let us not lose sight of the fact that the petitioner in both the petitions and at least one or two of the respondents in the company petitions proceed as if they are the owners of the entire assets of the company, while forgetting the fact that they are mere shareholders and they cannot claim to be the owners of the property owned or held by the company. In fact, proceedings have been instituted as if the petitioners and contesting respondents are entitled to share in the properties held by the first respondent company, which is a misconception. Merely because sons, widow, and daughter of late Shanmughan Sundram Nadar hold substantial shares, it does not mean they become the owners of the land or the assets of the company. Substantial portion of the case and claim has been made out only on that misconception. It is well settled legal position that there is nothing to warrant for the assumption that a shareholder has any interest in the property of the company which is a juristic person and which is entirely distinct from the shareholders. The true position of a shareholder is an investor. He will be entitled to participate in the profits of the company in which he holds shares, and when the company declares, subject to articles of association, that the profits or portion thereof should be distributed by of dividend amongst the shareholders. That apart, shareholder has got a further right to participate in the assets which would be left over after winding up, but not in the assets as a whole. Now, this is well settled because of the Bacha Gazda judgment, which has been set out. Now, my lord, the issue again is, my lord, whether he at all is entitled to partition of the assets held by the companies. All the arguments made before different courts, my lord, whether a shareholder has such rights, my lord, those arguments have been rejected. And not only that, my lord, if Lordship sees his affidavit in reply, if Lordship sees his affidavit in reply filed in GA2, he has admitted this. Kindly see, my lord, his affidavit in reply affirmed by Kaustubh Jhunjhunwala, which was affirmed, my lord, on 12th of September 2025. My lord, kindly comes to page 2 of his affidavit in reply.
Yes.
Kindly see, my lord, paragraph 3C towards the bottom of page 2. 3C.
Affidavit in reply.
Affidavit in affidavit in opposition. I'm so sorry. My application, the plaintiff has filed an affidavit in opposition.
Affidavit. Yes.
Not page 2, paragraph 3C towards the bottom.
Yes.
Yes, 3C. The plaintiff has filed the instant suit praying for a preliminary and final decree of partition and other reliefs in respect of half portion of shares. So his suit is essentially for partition of shares.
Yes.
Now, my lord, kindly see how how he admits further. My lord, kindly comes to page 5 of his affidavit in opposition, paragraph 9.
Yes.
My lord, kindly see towards the middle of the paragraph, a positive statement is I state that.
Yes.
Yes, I state that all the companies as mentioned in the Schedule B of the plaint are interrelated family businesses with members of the Jhunjhunwala family having a controlling stake. The deceased father of the plaintiff was a promoter director and a major shareholder with a controlling stake in each and every company directly or through subsidiaries. I say that the plaintiff has inherited his right title and interest of his deceased father in respect of, again, my lord, the shares of the companies as mentioned in Schedule B.
Yes.
Now, my lord, he is espousing rights because he says that he has inherited his father's shares. So his claim or his cause of action is on the basis that he has acquired the shareholding of his father, and it is on that basis that, my lord, he is asking for a decree of partition of shares which is not maintainable.
Yes. That's all.
My lord, one more, my lord, since, my lord, he has made out a case that there is a controlling interest also involved. But kindly see how the division bench of this honorable court in the Birla judgment has, where my lordship knows, my lord, Priyamvada Devi Birla, my lord, her estate was managed and controlled by the administrative APL, the administrator pendenti lite. Now, my lord, it was argued that APL had a controlling stake over all the companies wherein PDB was a shareholder. Now, my lord, that argument was negated by the division bench because, my lord, controlling interest cannot be more than what the law has provided. Lordship, my lord, only few paragraphs of this judgment, my lord, this is a very long judgment. My lord, kindly comes straight away, my lord, to, my lord, paragraph 167. My lord, which lordship will find at page 150 of the printout. At the top, my lord, the page numbers are given.
Yes.
Yes. A short answer, this was the issue. At paragraph 167, which is the last sentence of that page. A short question to the answer as to how far APL can interfere in the company's affairs has to be answered in a conservative manner. The APL stepped into the shoes of the deceased testatrix and cannot exercise powers which the testatrix herself did not have. PDB, being the owner of certain particular shares in certain companies, could only function as the shareholder of such companies. The shares and incidental rights thereto, such as voting rights, etc., were definitely the property of PDB, but her personal charisma, authority, and influence asserted over the other shareholders and companies definitely does not come within the purview of her property. Now, Mulad, kindly skip few paragraphs. Kindly comes to Mulad straight away to Mulad paragraph 180.
Yes.
Yes. Mulad, seen in proper perspective, thus, the present issue is dependent on the first issue, that is the extent of the estate of PDB. Thus, in so far as the companies are concerned, the testamentary court has powers over 1260 shares held by PDB, but also includes controls which such shares assert over the respective companies through voting rights and such sanction tools under the company jurisprudence itself. Shareholders, although not the owners of the company's assets, definitely have a crucial role to play in the decision making process through voting and ancillary rights. Thus, the majority shareholders of the first tier companies get to decide the way in which the said companies exert their voting rights as shareholders of these companies. Now, let kindly see para 182. Here, we must be very careful to distinguish the personal influence, charisma, and authority of PDB might have enjoyed over the companies, their directors, and shareholders during their lifetime from her rights as a shareholder of the concerned companies. Personal influence, control, sway do not translate into bequeathable rights and get extinguished with the concerned person. Rights as promoters or directors are not heritable and thus cannot be the subject matter of a will. Now kindly see Marat, paragraph 186 on the next page.
Yes.
Hence, the testamentary court can only have control over the shareholding and ancillary rights, including voting rights in the companies. Of course, the court cannot participate in the day-to-day affairs of the companies and precisely for such reason has appointed the APL to represent the estate. Testamentary court is not a company court and not sitting in judgment over the allegations of mismanagement and fraudulent actions or transactions of companies and thus need not live the corporate will in this context. Now, Lord, I am not going with the other judgments that have been discussed in this Birla judgment. The short issue or the important issue that has been, my lord, that my lord, APL was appointed by the testamentary court, my lord, to manage the estate of the lady, deceased lady. Argument was whether the APL could have exercised controlling interest of the lady on those companies. The answer was negated. The answer was in the negative. Because if a person at the end of the day is a shareholder, that shareholder, my lord, is only entitled to dividends if declared by the company. Shareholders, my lord, cannot have any right in the assets of the companies.
Yes.
Here, my lord, admittedly, on the basis of the plain case, he has not shown that he is a shareholder. Without being a shareholder, he cannot sue for partition. Now, suit for partition of shares is not maintainable at all. In that case, my lord, the plain does not disclose any cause of action.
Okay.
But these only two, so I'll just, but two, these are my two limbs of argument. Immovable property outside, hence, my lord, this court does not have territorial jurisdiction, and suit filed for partition of shares is not maintainable. But these are my.
Yeah.
It is also of a concept, it's not of a individual.
That is my case, Miller. That Schedule A property, Bright Street, that is why I've come before Miller. But Mr. Midora was saying companies can't be included, so on and so forth. My interest is limited, this is my company.
That's all.
That's all, my lord. So far as the rejection of plaint application is concerned.
Counsel for the defendant has concluded his argument in connection with GA2 of 2025 with regard to rejection of plaint. Full stop. Due to paucity of time, plaintiff did not argue the matter. According cases adjourned. Counsel for the plaintiff submit that the interim order is still today and paid extension of interim order. The applicant, namely, who has filed?
But Sunil Investments Private Limited.
Huh?
Sunil Investment
Namely,
Private
Sunil Investment Private Limited has filed an application being GA3 of 2026, praying for addition of parties. Learned counsel for the plaintiff prays for time to file appeal in opposition. Appeal in opposition if filed within 2 weeks, reply if there to be in a week thereafter. Full stop. List the matter. Oh, wait. 27th March at 3 p.m. Interim order is extended till 30th March 2026 or until further order becomes.
27th March.
No.
But I'm grateful, my lord, for at least specially fixing it. I know your lordship is very burdened. I'm grateful.
Ah.
My lord, they have the list.
Yes. Cost is ready with your pocket. Cost is ready in your pocket. Yes. Start.
Only difficulty, Sir Lordship, the reason being
Ah.
that the erstwhile advocate's name was appearing, my lord, as I have
None appears on behalf of the petitioner. No accommodation sought for. For the interest of the case adjourned, let the matter appear on 18 December. Then 18, 19 December.
indicate the order, my lord, page number 12. Page number 12, I have also annexed the earlier orders.
Page number 12.
Page number 12, my lord, is the impugn order.
Last order.
Yes, my lord.
If found from the record, is found from the record, matter was listed so and so, but on the said date, none appears on behalf of the petitioner. According to case adjourned till 18. Today also, when the yes.
But the difficulty was, my lord, as I pleaded in my paragraph number 8, the erstwhile advocate's name was appearing, my lord, as the advocate for the petitioner.
8.
8. Paragraph number 8, my lord. And my lord, the difficulty while checking the list, my lord, the advocate's name is typed, and my lord, accordingly, my lord, we find the cases. That's the usual practice, my lord. But absolutely, my lord, that's our mistake, my lord, what we have done. But that's why even we have issued notices to the registered, my lord, to change the name of the advocate in the list that is appearing. Lordship will find from page number 9 the case status that was there, my lord, at that point of time when the order was passed.
Page number?
Find page number 9.
There is no page number in your application.
Lordship, that just the
Annexer C.
Annexer C, your lordship. Lordship will find Shweta Gandhi that the name was appearing. This is the name that was appearing in the list as well as on
Where the Shweta Gandhi?
Your lordship, the petitioner and advocate, the name is written in the goods of Chandar Mohan Ghoda. Lordship, only the third paragraph.
Yes, Shweta Gandhi.
Yes, madam. The name was appearing, and that is why there was misunderstanding on our end as well. Lordship will also take just the next page. And I'll indicate page number 8, the previous one. This was the notice, my lord, where we have indicated the register, the change of Wakalat number, and accordingly, my lord, but still, my lord, the name was there, and my lord, it was our mistake that we were unable to, my lord, follow the matter. Therefore, my lord, we couldn't appear, my lord, on that.
It is not contested. It is contested.
It's, my lord.
What is the stage? What is the key stage?
Stage is, my lord, citations were issued. Thereafter, my lord,
nobody has appeared.
Nobody has appeared.
So
that even, my lordship, if the matter is restored, my lord, I'll pray for making this non-contentious cause.
So it's the case of regular court,
yes,
no?
Before the regular.
Before the regular court. Why it is listed here? Assign total assign only application.
This
Application. The petitioner has filed the present application being GA 1 of 2025 in PLS 62 of 2021, praying for recalling of the order dated 19th of December 2024, wherein this court has dismissed the PLA 62 of 2021 for default. Full stop. Learned counsel for the petition submit that the petitioner could not take a note of the case listed before this court either on 14th of November 2024 or on 19th of November 2024 on the ground that in the cause list the advocate on record of the petitioner is recorded as Swetha Gandhi within bracket Murgai instead of Tanmay. What is the name?
My lord.
Instead of which what name? Triptima Talukdar. Instead of Triptima Talukdar, who is the advocate on record. Full stop. Had the learned counsel for the petitioner peruse the materials on peruse the cause shown in the application, this court find that the petitioner has shown sufficient cause for non-appearance of the petitioner before this court on 18th of December 2020. 18th or 19th? On 19th of December 2024. Accordingly, order dated 19th December 2024 is recalled. Full stop. PLA 62 of 2021 is restored in its original file. GA number 1 of 2025 disposed of.
May I have a lordship's leave, my lord?
Date should be 25th of September.
Huh?
That should be 25th of September.
Ah.
10 days.
Ah.
Thereafter, second paragraph. And for that reason,
List the matter Tuesday as to be mentioned for correction.
Would it be your lordship's leave to have item numbers 3 and 4? Your lordships had taken this day before yesterday, but since the stenographer item numbers 3 and 4, my lords, the matter is right next to item number 2. Your lordships had taken this matter the day before yesterday, directed the contemners to be present on the 11th, my lords. Since the stenographer was not there, my lords, the order could not be recorded, a formal order. I was only beseeching your lordship if your lordship could only pass an order, my lords.
What order?
To the effect, your lordships will have item numbers 3 and 4. There, your lordships are directed, your lordships had issued a rule.
Give 3 and 4.
I would not have, my lords, mentioned this in the usual course because these are contempt petitions, my lords, hanging on for a long period of time. If your lordships just have, my lords, last order, 21st January 2026. That
21st of January?
Yes, my lords. That is an elaborate order, my lords, your lordship will have. By an order dated 12th September 25, this court issued rule upon alleged contemner numbers 1, 2, 4 to 7, 9 and 10. Accordingly, the rule was issued against contemner numbers 9 and 10. Then your lordship directs that the inspector in charge of Bardhaman Sadar police station is directed to file the report on the next date with regard to the service of the rules upon the alleged contemners.
Yes.
Either the contemners do not appear, or whenever they appear after regular intervals, they change the advocate on record, my lords. Because of which this is not being able to proceed any further, the contempt petitions, my lords. Which is why your lordships had passed an order dated 12th September 25 issuing rule upon them to be present personally, all the contemners.
Yes. So they are not residing. There's a report. All the containers are not residing in spite of the several efforts made in the said area. During
the contemners have come in with a new advocate on record now.
Hmm. 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 They will. Who are the respondent? Contempt number 1, 2, 4, 7 and 9. 7, 9 and 10. 1, 2, 4, 6, 7. So what about the 9? Who is the 9?
9 has not been appearing. 9 and 10 both, my lords.
Who is the 9 and who is 10?
Nimai Chand Shaw is 9 and 10 is
Okay.
Ijaz Ahmad.
The Deputy Sheriff of Calcutta has filed the report dated 4th of February 2026, wherein it refers that in terms of the order dated, very interested that a report is received from the inspector in charge of Bardhaman Police Station, Purba Midini Bardhaman, wherein it stating that all the contaminants could not be traced out at the mentioned addresses as well as in the surrounding area during the several raids. Full stop. So, what is the good name, madam? So and so appearing. So and so appeared before this court and submit that she has instructed to appear on behalf of the respondent number 1, 2, 4, 2, 4, 2, 7. 7 and submit that all the said contemnants will appear before this court on 11th of February 2026 in view of the submission made by the counsel for the alleged contempt number 12427 121, 2, 4 TO 27 7. Let the matter appear on 11th February or appearance of the alleged contemnants. As regard the contemnants number 9 and 10, the petitioner is directed to take appropriate steps.
I'm so grateful for the indulgence, my lord.
The advocate for the contempt numbers 1, 2, 4 and 7 is given liberty to file the wakalatnama in the department.
Grateful, my lord.